Can you please switch on your video, sir?
Video is on. Yes, just hold it. Am I visible to you?
Yes, sir.
You tell me when to start it.
Yes, definitely around 6 to 7 minutes.
Okay.
Good morning, participants. Can somebody from Arunachal confirm that you have all logged in?
Anlamcı Bharatiya Arunachal Pradesh, UP. Hello.
Yes, sir. We're just
Yes.
waiting for a couple of more minutes, sir. We'll start
Yeah.
in 2 minutes.
Now.
A very good morning to all participants. I'll request all of you to please go to the link and also fill up the joining formalities. Only 500 of us have filled up the joining formalities. Remaining have not yet filled up the joining formality form. So I'll just, let's take 2 minutes here and just fill up the joining formality form. Whosoever is remaining to be filling it up, please fill it up. And if you have arranged it in the format of having a class sitting together, then there is already another link for that also. So please fill up that link also so that we have an exact number of how many participants are there. We'll be just starting shortly in another 10 minutes.
Good morning to all participants. We will start the sessions for the day. I have the honor of introducing Advocate Shri Rahul Kasliwal. He has been practicing criminal law for the past 25 years, and he has conducted more than 4 dozen matters related to the Maharashtra Control of Organized Crime Act. He has also conducted many cases under the NDPS Act, so he's well versed with both the prosecution side on both sides of the aisle. He is designated as a senior lawyer in the presence of the Chief Justice of India. He is practicing both in the Nasik District Court as well as the High Court of Bombay. He is a guest faculty, regular guest faculty on criminal law at various law colleges as well as the Maharashtra Police Academy, and he's often invited by various bar associations to deliver lectures. So the academy has co-opted Shri Rahul Kasliwal today to talk about the implications, how to use the new provision related to organized crime and petty organized crime, which have found their place in the General Penal Code, in the new penal code, that is the Bharatiya Nyaya Sanhita. So the reason why we have co-opted a specialist for this is this is the first time in most states, in fact, in states other than, say, Maharashtra and Delhi, where there is a special law, special section that is going to help us deal with various organized crime that is happening in our jurisdiction. So till now, we would probably use abetment or criminal conspiracy to deal with these kind of groups or gangs. But now we have this act which is there in our general penal code. So before Shri Rahul Kasliwal takes over the session, I would like to kind of build up a narrative on to what you can expect from this session and what will our probable takeaways be. Yesterday, we looked at the definition of organized crime, and I'm sure that all of you have gone through the section in the BNS, and you have seen that now abetment, attempting, conspiring, facilitating, or even engaging in any preparatory act to the commission of an organized crime is an offense under 111 subclause 3, as well as if somebody is a member of an organized crime syndicate, that is an offense. If somebody intentionally harbors or conceals any person who has committed an offense of an organized crime, that has also been treated as an offense. If anybody possesses any property that has been derived or obtained from or proceeds of any organized crime, that is also an offense. And at the same time, even benami possession of any property is also treated as an offense under the BNS. And what we would expect, what we would request Sri Rahul Kasliwal sir to explain to us will be how has the police been using these sections in Maharashtra? How have we established an organized crime syndicate? How have we been able to prove that or establish that a particular activity is a continuing unlawful activity? What have been the comments of the court? How has the defense tried to break our case, or how has the defense been successful in getting the charges quashed, etc., and pointers into helping the local police deal with local level mafias. That is, we might be having small gangs who are engaged in chain snatching, in sand smuggling, in house breaking, robbery, etc. And how can we use this new section to kind of break their back and to ensure that this kind of organized criminal activity does not go on. As usual, the participants can please type their questions in the chat box. I will be making a note of them. And at the end of the session, I would request Sri Rahul Kasliwal ji to address those questions. Over to you, sir.
Thank you so much. Good morning, everyone. This is a new chapter which is introduced by the legislation with only one intention, that the uniform or central law or union law would be uniform throughout the country. Before this, there were some state legislations. As in the state list, those legislations were empowered to be enacted. And therefore, the legislation like MCOC Act in Maharashtra, GCOC Act in Gujarat, and in many states, the acts were in implementation. But many states were there where these type of acts were not enacted. And the question was that being a uniform process of enforcement of law, this was necessary. So I say it is really a nice step towards this enactment of this type of provisions in the new act, and which would curtail the crimes or repetition of crimes. These provisions are mainly made for those people who are committing the offense. Are you all audible?
Yes, sir. Please go on, sir. It is audible.
Yeah. So these are the provisions made with an intention to curb and curtail the repetition of crime by some organizations or by some group or gangs. In general IPC, we were aware about 107, 109, 120B, 149, 34. But while proving those sections, one thing was always there, that some ingredients of the offenses or the ingredients of those provisions were quite different than the present one. While explaining this act, I would like to say, what is punishable under the act is organized crime and not the continuing unlawful activity. As organized crime is the crime which is required to be punished or dealt with the strict hands. As far as the continuing unlawful activity is concerned, that is one of the ingredients of the offense. That itself is not punishable because continuing unlawful activity is in respect of the charge sheet in the last preceding 10 years, whereon the court has taken the cognizance of the offense. The most important thing, while understanding the organized crime, first we have to understand what is the continuing unlawful activity. As the continuing unlawful activity is the important aspect which shows that there should be 2 charge sheets in the last preceding 10 years, wherein the court has taken cognizance of the offense and the offenses are punishable for 10 years, for 3 years, and those are cognizable offenses. While doing so, I will just give one example. Very nice example I used to give in many cases. Suppose for a moment, there is a case of 498A. That is a case of cruelty to woman. Whether if a person is prosecuted for the offense of 498A, which is also punishable for 3 years, which is also cognizable offense, wherein also the question of pecuniary benefits or economic things arises, as there are always allegations of demand of money in 498A. Whether that act also come within the sweep of organized crime, that will be the question. But certainly, that cannot be. What is important, what is the purpose of enacting these provisions is required to be understood. It is not so that even a matrimonial case like 498A or family matter, the legislation is intending to have such type of draconian provisions or stringent provisions to be applied. So it is required to be understood what exactly the legislation wants to achieve by enacting these provisions. Because suppose for a moment, a person is committing offenses against again and again, but those offenses are of a private nature. Well, I'm saying of private nature means either of a family disputes or otherwise. Even it can happen that in family disputes, the brothers or families can have multiple cases against them. Then also we can call it as whether it will be an organized crime. Certainly the answer will be no. So what is important that is required to be considered. And while doing so, I really feel that the mens rea is required to be presumed while understanding these provisions of law. For the sake of moment, if we peruse the definition of continuing unlawful activity, it says that means an activity prohibited by law, which is a cognizable offense, punishable with imprisonment of 3 years or more, undertaken by any person, either singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charges have been filed and court has taken the cognizance. I will not go by word to word with the definition, as I know the practical examples will help you to understand the things. So while understanding the continuing unlawful activity, important aspect is that, or what police authority is expected to do, they have to collect the 2 charge sheets or the cases, pending cases of the persons on which the court has taken the cognizance. Whether those cases are disposed of or not, it is not a question. Whether there are acquittal or conviction, it also won't make any difference. So it is not material whether there is acquittal in those cases or not. It cannot be a stand of the defense that those cases are acquitted and now those cases cannot be considered as a for the purpose of continuing unlawful activities. Because what is important only, the court has taken the cognizance of the offense, that is sufficient. So those 2 cases in the last 10 years, will be the one factor or one ingredient to complete the offense of organized crime. As organized crime is a composition or a compound of three incidents. Two are in past and one is in present, which is under investigation or which is for which the persons are tried. So the third incident is also important. Third incident is must. Unless and until there is a third incident, there cannot be the organized crime. We cannot prosecute the person merely by collecting the earlier charge sheets and making a case that because of this they are coming under the purview of organized crime. That cannot be so. The third incident is must. And while doing so, if third incident is not proved, then the person cannot be convicted. The third incident or the incident which is in question is required to be proved. Then only the person can be convicted for organized crime, otherwise cannot be. Now question arises, what type of charge sheets are required? So that is very important to understand. I will go with a very crucial word of the definition without taking more time of you on. Undertaken by any person, either singly or jointly. It is not necessary that every time there should be whole gang available or whole gang should be present in the crime. What is important? Even a single person of the gang or group or syndicate committing the offense is also sufficient. But question is what? That offense he has to commit either as a member of the syndicate or on behalf of such syndicate. So that act should be towards the benefit of that syndicate. Otherwise, it won't come under the definition of continuing unlawful activity. I would like to give an example. Suppose for a moment, A, B, C, D, four are the people who are having gang and committing such type of offenses. But what happened? B is a married one and there was a dispute between him and his wife. And therefore, he assaulted her and therefore wife has lost the FIR for 498 406. Those are also punishable for 3 years, cognizable offenses, non-bailable offenses. But whether that offense can be considered as an organized crime? Answer will be no, because that offense is a private offense or of a private nature, or it is a matrimonial dispute between both those two. That offense has no nexus with the syndicate. And therefore, that offense would not be considered, cannot be considered as a offense as an organized crime, or cannot be considered as one of the factors for continuing unlawful activity. So what is important? Either by single person or more than one person. Important is what? That offense has to be committed on behalf of syndicate or as a member of syndicate. In short, the syndicate is to be benefited because of that. Then only it will be an offense. I will give another example, how it will be attracted. That example I would like to give. Suppose for a moment, there is a infamous chain snatcher who used to snatch chains in the market every day or in a week or two. Suppose for a moment, as generally it happens on two-wheeler. So one is a riding two-wheeler and one is a pillion rider. And it is their modus that sometimes he will ride, sometimes another will ride. Or they may change the person who can ride the two-wheeler. But they are committing such offenses repeatedly. Then the question would arise, whether the person who is riding the only two-wheeler will also come under this? The answer is yes. It won't make any difference whether the rider is same or another one, because those persons who are committing the offense, it's facilitating the offense, aiding the commission of offense, and their intention is to have such type of offense again and again, either by use of violence, intimidation, coercion, or threat of violence, or by any other unlawful means. And intention is what? It is an economic offense. As thereafter they are going to sell those products, sell those ornaments in the market. Question is that, in addition to, I will go further. Suppose for a moment, certain goldsmiths are again and again purchasing those type of articles. And while purchasing those articles, there is a sufficient material which is suggesting that they have knowledge that these are the stolen properties or robbed properties or properties in dacoity. Either it may be 411 of Old Act or Old Act means the Act in present, IPC, or 412, whatever it may be. But if that goldsmith or if that merchant or if that businessman is purchasing it again and again, and there is a material to suggest that he is doing it again and again knowingly, then he will also come in that gang, in that organized crime syndicate. He cannot say that I was not available at the spot, because what is important is a organized crime by 2 or more persons. So question is not important as to whether there is the same members or another members. That examples can be given by even different ways. Suppose there are 5 people who are having gangs, but every time they are changing the persons to commit the offense. It does not mean that we cannot prosecute all of them. The important word in the continuing unlawful activity is that in respect of which, what is the important? If we peruse the definition, what is mentioned? Singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed. So the charge sheets are required to be filed against that syndicate, not against the person. Syndicate is to be prosecuted. Suppose for a moment, one charge sheet is against A. One charge sheet in the last 10 years, one charge sheet is against A, one charge sheet is against B, one charge sheet is against C. But all three are a syndicate. They cannot say that there is only one charge sheet against me and there are no 2 charge sheets, so I cannot be prosecuted for organized crime, as the continuing unlawful activity is not fulfilled, as there is a requirement of necessity of 2 charge sheets. So what is important? The charge sheet should be against syndicate, irrespective of the person. Though it is against A, that also will be considered. Though it is against B, that also will be considered. Though against it is a C, it also will be considered. What is important? The nexus. What we have to investigate is the nexus between we three. You have to bring it before the court. You have to collect that type of evidence that these three are the syndicate. These three are the members of that syndicate. And though those are the charge sheets against a single person, but they have acted those acts, they have committed that offense on behalf of syndicate or as a member of syndicate. The question will arise, how it is possible? Answer is that in your charge sheet, it is required to be mentioned. You have to investigate that part, that A is committing the offense, B is facilitating the post-offense aspects like selling the property, carrying the property, concealing the property, harboring the accused, or any other thing, disappearance of evidence, whatever it may be. But they all are going to commit the act in concert, conjoint act. Though it is not on the spot, but they all are taking participation, act in partnership. Act in partnership. Someone are doing this, someone are doing that, someone is doing this. But they all will be considered as a syndicate if we have collected that material of evidence in investigation. Question will arise how that investigation is to be carried out. Now in modern technology, the most important part will be CDR, SDR, to show the nexus between those. If they are calling each other before incident, if they are calling each other after incident, or it is shown that they are in contact, then that will be the crucial evidence. Second important aspect, if one is committing offense on a day, another is committing offense on another day, but those three are disposing the property or taking the benefit of that property by dividing the shares of each other, then also they will be considered as a syndicate and member of the syndicate. So what is important in continuing unlawful activity is a syndicate is the person, I can say, who is to be prosecuted. So this defense will not be available because when MCOC was newly enacted in Maharashtra in 1999, these type of arguments were very common, and even the courts were also not very well uh, aware about the provisions at that time. And in many cases, on those grounds, the bails were granted, even the persons were acquitted. But thereafter, law is developed again and again. And the legal position is now settled one that the person should not carry, it is not the requirement of law that every member should carry the 2 charge sheets against him. So this is very important to understand. It will be otherwise difficult. It will be otherwise like a hide and seek with the police. Because being a member, suppose for a moment, I am head of the gang. I am the master of the gang. And I am using my brain. And every time I am sending another members or using another persons to commit the offense. That won't make any difference. What is required to be shown that this all is going on under my membership, my guidance, and I am running this gang like this. So I am unaware. I am not committing any offense by personally appearing on the spot. But then also, I will be the kingpin of the offense. That is most important. So this is really important to understand how that continuing unlawful activity is required to be proved. The second question is that what is required in earlier charge sheet? There should be material, there should be evidence, there should be statements of the witnesses, or it should be revealed in the investigation that this is a gang. This is a gang. It cannot be like that A has committed offense and you are investigating only on that point, that A has committed offense and committed theft or housebreaking in the house of XYZ. If you are not in position to show that A and B had nexus with each other, then that charge sheet will not be any use, will not be of any use. One famous case is there of MCOCA, which is decided by Honorable Supreme Court, wherein one of the police commissioner of Mumbai, the case was Brahmajit Singh Sharma versus State of Maharashtra. That was a case wherein the commissioner of police of Mumbai was also arraigned as an accused, and he was in jail for 2 years. Why? That was a case of a Telgi scam. Printing of counterfeit notes and counterfeit stamps and like that. In that case, merely because being a public servant, some provisions of law were not fulfilled or were ignored, or there was some benefit to that Telgi, the concerned commissioner of police was also arraigned as an accused, being a member of that gang. He was in jail for near about 2 years, and thereafter he was granted bail. So these are very serious provisions. No doubt in MCOCA, but now in our general law, now we can say call it as a general law. As in general law, though those provisions are not that much considered as serious as in special act. But what I'm trying to say, any person can become a member. Even I would like to say, many times it happens that even though we are aware about the act of certain person or habitual offender or the company of habitual offender or his associates, we used to prosecute only 1 or 2. As it happens that there is no evidence against others. But that will be the real test that we have to find out. Otherwise, we won't be in position to call it as an organized crime syndicate. Second important aspect, what is organized crime? And now this definition is widened. Means this definition has a wide scope than MCOC Act also. You all must be aware. I am not aware about the laws in different states, but in Maharashtra, there is a provision of Maharashtra Prevention of Gambling Act. Like in Maharashtra, in various states, there are different provisions in respect of gambling. But those offenses are bailable. Those offenses are bailable and are punishable up to 2 years. So the question arises, suppose nowadays, as we all are aware, of online frauds or match betting, match fixing, or we can call it as some gambling, online gaming is also going on. But as those gamings are coming under the Gambling Act, which are punishable up to 2 years, I am talking about Maharashtra, and whatever may be the punishment in your states. But if those offences are not punishable for more than 3 years, then also it will be of no use. We cannot book them in organized crime, because earlier charge sheet should be of those offences which are punishable for 3 years. So those are offences of gambling, those are of a pecuniary benefit or economic offence or like that. But at the same time, there are many cases wherein we used to register the crime under 420 also. Though not in gambling, but in online frauds, we used to register offence under 420 or other sections of IPC. In those cases, we can register the offence under the organized crime also. And one important thing, while we are registering the offence, for a moment, suppose we are registering the offence under 111, it does not mean that we cannot register the offence under the other provisions of law, like the present, for the sake of moment, I am giving an example, that suppose for a moment, I am committing an offence of under the provisions of Immoral Traffic, Prevention of Immoral Traffic Act, and I am running a brothel. Suppose for a moment I am running a brothel, and many women are found. Those are also, police has raided the premises and found that there was such type of prostitution was going on. The question is that now, because of new provisions wherein the human trafficking and everything is considered as an offence, the question arises whether you cannot register the offence under the provisions of Immoral Traffic Act. The answer is no, you can, because this is the additional provision. This is the additional provision in addition to other provisions of law. Either it may be under Bnss or it may be under the special provisions of any law. So we can register the crime under the Immoral Traffic Act. In short, we can call it as a PITA Act, under the PITA Act and IPC also, or Bnss also. So those offences are punished under that act also and under this act also, because under this act we are going to punish that syndicate, and whatever the crime proceeds or the money or properties they have derived out of the crime proceeds, that also we can attach or we can collect those properties. Under the old act, the police had no authority to attach the property. Under section 100 and 102 of CRPC, the present CRPC, I am saying of 1973, the police had no authority to seal immovable property. The police had authority only to seal movable property. But these changes are there. Now police can do something more than earlier old law. Now the question is that what is the meaning of organized crime syndicate? And it is mentioned here that organized crime syndicate means a group of 2 or more persons. In NCOC, there is a definition of more than one person. The meaning is said, minimum 2 persons are required or more than that, who acting either singly or jointly. This is very important. This itself suggests that there is no necessity of joint act every time. As a syndicate or gang indulge in any continuing unlawful activity. So what is important? That they have to commit the offence as a syndicate or on behalf of syndicate. Then only we can register the offence or we can book them under the provisions of organized crime. There are 2 sets. One is called as an organized crime and one is called as a PT organized crime. That has been differentiated only because of the nature of offence. And somewhere it appears to me that legislation has thought it fit that the severe punishment for 111 cannot be imposed for PT offence, PT organized crime, and therefore the differentiation is being done. But at the same time, I would like to say something more. Suppose for a moment, in PT organized crime, there it is mentioned that even the selling of the question papers of public examination will also come under this definition. We all are aware about the recent position of NTA, the NEET examination papers and all those things we are aware, and it is everywhere we are hearing it on news. So the question arises, as it is a question of national importance, whether we can call it as a PT organized crime. How it can be PT when it is affecting the whole nation or the career of lakhs of the students? But that is not our question, as the legislation has mentioned it as a petty offense. But if we peruse the provisions of 112, section 112 of Bnss, wherein the petty organized crime has been mentioned, whoever being a member of a group or gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets. Unauthorized selling of tickets means the Lottery Act. I am not aware about the your states, but Lottery Act is a central act. Under the provisions of Lottery Act, if someone is selling section 9 of the Lottery Act, that if someone is selling the lotteries or tickets of lottery unauthorizedly or illegally, then that is also an offense under that act. So unauthorized selling of lottery tickets. In addition to that, unauthorized betting or gambling, I just said. The question will be the same. How the gambling will come under it? If gambling is not punishable for more than 3 years and it is a cognizable offense. No doubt it is a cognizable offense, but it is not punishable for more than 2 years in Maharashtra. Or keeping a gaming house is also not punishable for more than 2 years. Selling of a public examination question papers. This is very important. Or any other criminal act is said to commit petty organized crime. An important aspect is that while defining this petty organized crime, they have not made different definition for continuing unlawful activity. So the difficulty will arise if the continuing unlawful activity is the same. Definition of continuing unlawful activity is same for both the offenses, either for organized crime or for petty organized crime. Then question will arise, how those people can be dealt with who are having no charge sheets in last 10 years for the offense which is punishable for more than 3 years. That is the difficulty. And the second difficulty is that how theft can be called as a petty offense, because theft has no limit of the monetary limits. Theft can be of 100 rupees and theft can be of crores of rupees. We all are aware about the ATM machines. ATM machine means theft of ATM machines is considered as a petty organized crime. Generally, we used to take it so seriously as it is affecting the national economy also and it is disturbing the public conscience. But the legislation has considered it under the provisions of petty organized crime. And what is considered as organized crime is important. But again, I would like to say one more important aspect. While mentioning it, organized crime cannot be only limited to one state or nation. It can be even out of the nation. Because many times it happens that organized crimes or the conspiracy of organized crimes are hatched overseas or in abroad. In that case also, now under this law, if we peruse the provisions of section 1 and 2 of Bnss, we will be in better position to understand. The scope is now widened that even we can we can even investigate abroad, or even any offense is committed out of India and which is punishable in India by Indian citizen, then also we can deal with it. Because in now modern world, like social media or like online fraud can be at any level, at any place, throughout India or even out of India. So then also we can register the crime for those offenses. Even we can register the offense against the foreign nationals if that is an offense in India. So what is important now, the scope is widened so much, and that is required to be considered. Suppose for a moment, like a question of betting or gambling, as I used to handle such cases many times, like betting, as there was a IPL some days before, or now, right now there is a World Cup, and suppose one match of match betting was fixed. One case of match betting is registered under the provisions of Gambling Act, even under the provisions of 420 and other section, and the money is circulated, and that money is circulated online, as they used to send link, and by that link the people are using to have some points and used to send money. If that money reaching to Dubai for a moment, if the beneficiary is in Dubai and some of the people are in, either one is Maharashtra, one is in UP, one is in some elsewhere, then also any police can register the offense, either of the UP, either of Maharashtra, or even anybody. So territorial jurisdiction is not a question for such offenses now, and we can register the crime anywhere, wherever the consequences are ensuing for that offense. So what is important, even the persons who are abroad and they are just taking the benefits of that illegal act can also be booked, and they can be also considered as a member of organized crime syndicate. They can be treated as a member. Thereafter, it is also not important for a moment. Suppose in one act, one of the member has not taken part in the present crime, but he is a member in earlier offences, or he is an active participant in earlier offences, or though he has not taken active part, but still he is a member of that gang who is facilitating the crime, who is doing the preparatory act, or who is trying to disappear the evidence. Then also that membership itself is also punishable under Bnss. So these are the important factors which are required to be considered under these provisions. I think my time is near going to be over soon. So,
yes, sir. Sir, I have just two queries, sir. First one, since in petty organized crime, there is no mention of continuing unlawful activity or no mention of an organized crime syndicate, can we take it to mean that 112 can be invoked even if a particular group or gang engages in the offenses mentioned in that particular section even for the first time?
Very nice question. Really very nice question. Important is what? Though it is not mentioning petty organized crime about unlawful activity, but the definition of organized crime is given in 111. So all the ingredients of 111, like continuing unlawful activity, is required to be fulfilled. We cannot prosecute someone merely because of one incidence of theft. There should be 3 incidents, 2 in past and 1 in present.
Okay, sir. So taking lead from your session, sir, if I can propose a hypothetical scenario that there has been a series of snatchings in the particular jurisdiction. So as soon as the first snatching happened, a particular case was registered either under robbery or 382 or something like that. And then 2 accused were apprehended and charge sheet was filed against them. Subsequently, there was another incident of snatching. 2 other accused, not the same accused in the first offense, but 2 other accused were secured, property recovered, and charge sheet filed against them. Subsequently, when the third snatching happened, case was registered, and in the third case, it was revealed that the 2 new accused in the third case were connected with the 4 accused in the previous case, and there were in some kind of nexus. Now, in the first 2 instances, there is no mention of any nexus between the 2 accused in the first case or the 2 accused in the second case with some other gang or some other larger gang. But in the third case, when it was registered, when they caught the two new accused, the police have been able to establish that this third instance was in fact connected to the first and second instance. Now will we be able to invoke? Of course, there are 3 FIRs that is done. Now, can a 4th FIR be registered under section 111, linking these 6 people as part of an organized crime syndicate?
Very nice question. You can book all of them in third charge sheet itself.
Third charge sheet itself for organized crime, sir?
392, read with organized crime.
Read with organized crime. Even though in the first 2 charge sheets, there was no mention of nexus or there was no mention of gang.
I understood. What happened? In first case, suppose for a moment, in first case, there was A and B. In second case, there was C and D. Am I right?
Yes, sir. Correct, sir.
And in the third case, what you are saying?
There is E and F.
Okay.
And we were able to establish that E and F were actually connected with ABC.
In the third incident, there is a E and D. While investigating the third offense, you understood that, or it is revealed that, though these are the E and F, but B and A, B, C, D were also having nexus with them, and E and F were also having nexus in the earlier crimes. Am I right? Are you going to say the same?
Yes.
So the question is that this evidence you have collected in third incident. And
yes,
it was not
after the third incident. Yes.
Yeah. During the investigation of third instance, you collected this evidence.
Yes, sir.
Now question arises, what is your question is that whether you can book these people, earlier people in the third incident, or whether you are required to register the 4th FIR.
Whether we can bring them into the third incident is not an issue, sir, because if we are able to prove that they were abetting or conspiring and whatever, but can these 6 people be treated as part of an organized crime syndicate? Can we book these 6?
Exactly that I am saying. If you have collected the material to show their nexus, and their participation even in earlier crimes, then you will be in better position to book them under the organized crime.
Okay, sir.
Answer is that, yeah. You know, there are some judgments which are against this proposition, and some judgments are there which are holding this proposition. But, but one thing is very clear. In third charge sheet, you will have to mention it. Because what I am trying to say, this is a very nice question. Because though earlier 2 charge sheets are already taken care by the court, already the cognizance is taken for a moment, suppose they are acquitted. For a moment, suppose they are acquitted in earlier 2 charge sheets. But what you are going to punish is the third incidence. In third case, earlier 2 charge sheets, it is not question of double jeopardy. It is not a question of res judicata. Because what res judicata or double jeopardy says, the same person cannot be tried for same offense. For same offense, not for same case. So earlier there was no organized crime applied. At that time the evidence could not be collected or whatever it may be. But in third case, if that evidence is collected that in earlier cases also there was a nexus, and in third case only by giving the in custodial interrogation of the accused in third case, we came to know about all these things, and thereafter we investigated the crime, and now we are in better position to book those persons also. Then we can register the offense even against those 4. In addition to this present 2, like 6 persons, under the provisions of, means what will happen now I will say. It will be an offense under 392, read with provisions of 111 or 112, whatever is applicable. If it is a robbery, 392, it will go under 111. If it is a theft, it will go under 112. So this is very important aspect. Very nice query.
Okay, sir. Last question, sir, just to clarify for all the participants. Now, 3 incidents of a particular type of unlawful activity, punishable greater than 3 years. It is not necessary that all the accused of that organized crime syndicate are associated directly or indirectly with all the 3 offenses. If there is some kind of nexus proof, that is sufficient. Correct, sir?
Exactly that. I repeatedly mentioned it in my lecture. Suppose for a moment, there is a gang. Suppose I am running a gang. I have 5 members. A, B, C, D, E. These are my 5 hunters. And what I am doing, sometimes for the first offense, I have A and T only participated. For the second offense, only C has participated. And for the third offense, only D and E have participated. Then also, you can book all of them because the charge sheet should be against syndicate, not against person. It should not be so that every person should carry 2 charge sheets in the past. The antecedent should be against that syndicate, not against that member. What is important? Those acts should have been committed either on behalf of syndicate or as a member of syndicate. You got my point?
Okay, sir. Got it, sir. The last thing, sir, can we, let's say we have more than 2 or more charge sheets against a particular syndicate.
Yes.
Can we book a separate offense under 111 or we only have to book it read with a particular offense in the BNS, which has more than 3 years? Can this 111 be a separate offense?
Yes, exactly. As in, right, for the sake of moment, the present scenario I am saying.
Yes.
Like under IPC for a minute. Suppose 5 persons or more than 5 persons has committed offense of 302. What we used to do? We used to register the crime under 302, 147, 148, 149, whatever it may be. If suppose for a moment, person is acquitted of 1 or 2 persons are acquitted from 302, but they can be punished for 148 for holding dangerous weapon, being a member of unlawful assembly or like that. If assembly itself is not proved, then individual act will be considered. But what I'm saying in BNS, suppose for a moment. Hello.
So now, sir, like if being part of an organized crime syndicate itself is a separate offense.
It is an offense in addition to the other offenses of BNS. Means suppose chain snatching. We will take an example of chain snatching.
Okay, sir.
We are going to register the crime against them under the provisions of robbery.
Yes,
suppose
sir.
We can call it as a section 392 for a minute. Okay. It happened for third time. So robbery is punishable for 10 years. Okay. Robbery is punishable for 10 years.
Yes,
and
sir.
111 or 112 is punishable for less than that. Suppose for a moment, this is the difficulty what I am trying to say. As robbery is punishable for 10 years or even 14 years also, or 394 is punishable up to life. But what organized crime is saying, if you peruse the punishment, then the question will be that the punishment for organized crime is given. If there is a death, then it will be life or death, like 302. If there is no death, then it will be for 5 years or imprisonment for life, as the punishments are given under the Act. If an abatement, attempt, everything is punishable. But if suppose, for a moment, this is very good question you have asked. Exactly that was the difficulty. Suppose for a moment, if we peruse the section 112, petty organized crime, wherein the theft is considered and many other offenses like cheating, selling of papers, gambling, betting, unauthorized, and many other things. What is important? Suppose for a moment, there is a housebreaking between after sunset and before sunrise. So under the provision of 457 or 454, there is a higher punishment than this. So we have to register the offence under the provisions, general provisions. Those are, suppose for a moment, 392, 454, 457, whatever it may be. Read with 111 or read with 112. As we were using it, read with 34, read with 149. Are you aware?
Okay,
Hello?
sir. Yes, sir. Yes, sir. I'm hearing.
So like that. So like that. Because it will be an additional punishment. Suppose 392 is proved against 2 persons who are actually doing that. But we have booked 4 persons. Other 2 we have booked as a member of syndicate or otherwise, because we are trying to prosecute the syndicate. So, though the other persons who have not actually participated in the third crime can also be punished if we are in position to prove their nexus as a member. As a member.
Okay, sir. Since we are running out of time, sir, the last question that I have is, now let's say that the second incident has happened. First incident, we have registered a charge sheet. We have registered a case, filed a charge sheet. Second incident has happened. Now what I do is I actually file the charge sheet without invoking section 111, any of the subsections, that is either harboring or attempting, abetting or member. I file the charge sheet under 392 or any other section. And then I file a separate FIR under 111, thereby fulfilling the requirement for 2 charge sheets. Will that be permissible, sir?
No, third incident is must.
Okay. Third incident is a must to register, to invoke section 111.
111 or 112?
112. It cannot be a standalone thing that I file 2 charge sheets and then now I invoke 111.
Because what I am trying to say, officer, because earlier charge sheet is only one of the requirement. Continuing unlawful activity is only one of the requirement of organized crime. It is one of the ingredient of the offence. That otherwise it will be, suppose for a moment, as you said, first charge sheet is filed, second charge sheet is filed, and now third you are registering on the basis of earlier 2 charge sheets. Then it won't be called as an organized crime because there is no third incident. And suppose for a moment, out of the earlier 2 charge sheets, in one charge sheet, 1%, the people are acquitted.
Okay, sir.
So the third incident is a must.
Okay, sir. Now we have one question from the chat box, sir, that they have a case in crime number 2 of 22 and another case in 5 of 23. So in 2022 and 2023, they've registered 1 case each. Both cases are charge sheeted. Now in 2024, after Bnss has come into force, a case has been registered. Can I invoke section 111 in 3 cases with the 2 earlier cases?
Absolutely. I was anticipating this query. Suppose for a moment, one earlier crime is of 2022, another one is a 5 of the 23, and next one is, suppose for a moment, 1 of the 2024 in the month of August.
Yes, sir.
Okay. Then also you can register the crime under 111, though the Bnss was not applicable earlier. Because what exactly that I am trying to say, earlier charge sheets itself is not an offense. Earlier charge sheets is only a requirement to one of the ingredient. One of the ingredient. Unless and until there is a third incidence, the earlier charge sheets are of no use. And if there is a third incidence, then the 2 earlier charge sheets can be used, even though the accused are acquitted or convicted in earlier cases.
Okay, sir. Can we take one more question? Last question. What shall be the evidence to connect the earlier offenses with organized crime? Usually it is nothing more than CDRs which are only suggestive and not conclusive to connect the members of crime syndicate. So sir, in your experience, if you can give one or two examples on how they have managed to connect people, sir.
I will try. As far as CDR, SDR concerned, you are aware. Okay. If there is a chatting or like that, then that also you are aware. Suppose for a moment, while investigating the third crime, during the custodial interrogation, one of the accused has given an information about the co-accused, and that co-accused happened to be the accused in the earlier cases. And he gave the information as to how they are doing it since last 10 years or 20 years, or 10 years for a moment. The minimum period is considered as a 10 years. Okay. Then the question will arise, if during the custodial interrogation, he is giving more information. Suppose for a moment, I will give one example. Suppose for a moment, in the third custodial interrogation, the accused confessed before you, though it is not admissible but can be used for investigation. He has given you an information that 5 years before we have committed the same offense, and one of the co-accused, who is the accused in the earlier case, suppose we will call him as A. A was also with us, and he has taken all the money from us, and he has purchased one bungalow out of that amount. Or he has purchased one car out of that amount. Then you have to investigate that part, from where the accused A has purchased that car or that bungalow, and what was the source of his payment. And if he is not in position to explain the payment, then it will be presumed that it was out of the sale proceeds of the crime, because then burden will be on him to explain that. Okay, it happens many times. Some of the accused used to go on sleeping mode after commission of some crimes. Especially, I am talking about the economic offenses. I am saying. Suppose for a moment, like one example I can give. I am not aware about your state, whether there is any act like act in Maharashtra like MPID, that is a Maharashtra Interest of Protection of Depositors Act. Like in Maharashtra, there may be any other act in your state. Is there any act like this?
Yeah, in quite a few states we have this act. Sir.
So what happens? These type of people used to launch different schemes in different states or after the intervals. Sometimes they used to say, deposit the money, we will give the 20% returns, 24% returns. They used to collect the money from the people by giving different offers. Some used to give, you plant some plantation, you do this plantation, you do that plantation, you will get the benefit, or like to give some rabbits, like to give some emus. These type of cases they used to register. What they used to do, they used to launch different schemes after some intervals. 2 साल में ये, 2 साल के बाद वो, 2 साल के बाद ये, ऐसा वो करते हैं. और होता क्या है इन सच केसेस? सपोज फॉर अ मोमेंट, उन लोगों का कुछ एक ग्रुप है, एक राज्य के लिए एक ग्रुप है, दूसरे राज्य के लिए दूसरा ग्रुप है, तीसरे राज्य के लिए तीसरा ग्रुप है. लेकिन अगर हम ये बता पाते हैं कि these are different groups in different states, but they have their nexus. They are under the one leadership. They are circulating the money of this scheme into that scheme. Then also you can book all of them, all 3 gangs, all 3 groups, though they are in different states. It won't make any difference as to whether it is in Maharashtra or in Tamil Nadu or elsewhere.
The last question I can see, I will be able to answer it and sir can correct me if I'm wrong. So a participant is asking, if a new member joins a gang, can he be roped in for the past acts of the gang in the case?
No.
And he can be booked under 1114 for just being a member of an organized
Only.
crime
Yes,
syndicate,
only being a member.
but
Only
not
being
for
a
the
member.
previous acts.
No. Only he will be only being a member, and that's why only membership is also punishable.
Only membership, yes.
Yes. Therefore, membership is been punished separately.
Separately. So that will be a separate FIR registered under 1114.
No, there will not
No?
be separate FIR. FIR will be same. Offense will be against that fellow.
Okay.
As in today's provisions,
Okay, sir.
for the sake of moment, we used to register the offense under 201 or 212. Suppose one has committed murder and another has disappeared the body. What we used to do, we used to register the offense of 302 against one accused and offense of 201 against another accused who has concealed the body. Like that, in the same FIR, that person will be prosecuted for the offense of 111 subclause 4. The charge will be framed separately.
Okay, sir. Okay, sir. So thank you, sir, for giving this very comprehensive overview and trying to address the questions of the participants. I am sure that there will be more and more questions that will be coming up as this law is enforced and it is start being used. And I think courts will also start passing a lot of judgments which will clarify and bring more clarity. Although this is not a new provision in our criminal justice system and it has been used by many states, so there are judgments already available. But once
many
I think,
judgments are there.
yes, sir.
Absolutely many judgments.
Yes, sir.
And I would like to address to all the officers who are hearing me that we need not there is no need to afraid by new provisions, no need to be overcautious about new provisions. This is like, in a different word, I would like to say, it is like in most of the cases, old wine in new bottle. It's like that. Merely numbers of sections are changed, subsections are added, but the necessary ingredient of offences are same as it were before also. So no need to be worried. Even the earlier judgments will also applicable to such cases. For the sake of moment, there is the offence of 306, abatement to commit suicide. In New Act also there is the case of abatement to commit suicide. So the definition of abatement is not going to be changed any time. So the old judgments will also be applicable. That won't make any difference. These are only sections or some new additions and some deletions are done. So I request you all officers, don't worry. These all is going to be similar. We will be very familiar with all these provisions in some days, and everything will be going on against as it is going on now.
Right, sir. Thank you so much, sir, for sparing your valuable time. And on behalf of the National Police Academy, I would like to thank you for addressing this session and bringing a lot of clarity regarding organized crime in the Bnss. Thank you so much, sir.
Thank you so much. Yeah. Okay.
Okay, dear participants, we are just halting it for 5 minutes because the next speaker is joining in. So we will be starting the next session at 10:40. Good morning, Atul sir. Am I audible, sir? Sir, you're visible, sir, but you're not audible, sir. आप mute पे हैं, sir. आप क्या कर रहे हो ये? म्यूट है सर, नीचे छोटा एक बटन है सर, वो दबाना है सर. हाँ सर, नीचे
Right.
just
Now.
yes sir, yes sir.
Now, right.
Sir. So we have the presentation here, sir, and we'll be sharing it from our end here, sir. So if when you are, we'll just have another 1 minute to go, sir. We just give them a 5 minutes break. So
Right.
so from this 10:40 onwards, sir, we'll go approximately till 12 o'clock, sir.
So, ma'am.
हाँ जी. All participants, we'll be starting the new session now. And the same request is continuing that please put your messages in the chat. Today, for this session on Bharatiya Sakshya Adhiniyam, we have our in-house faculty, Shri Ajit Pratap Singh, AD, here in SVP NPA, in-house faculty for Indian Evidence Act, as well as we are joined by an expert from Delhi, Shri Atul Srivastav sir, Senior PP. Sir, it's an honor for me to invite you and also introduce you to the entire gathering, sir. Thank you on behalf of NPA. Thank you so much for accepting our request and joining us today, sir.
Thank you.
Sir, so we have Shri Atul Srivastav sir. Atul Srivastav sir had completed his LLB in 1994 and sir joined the prosecution in 1999. So sir has a very illustrious career in the prosecution. Since 1999, he has worked in many high courts like Madras, Delhi, Goa, or even on behalf of Delhi government and Delhi police. Sir was a special PP in many sensitive cases that we have all heard of. That is the Uber taxi case, Danish woman rape case, cash work query case, and then Miss Sunanda Pushkar case, the honey trap case, juvenile Mercedes accident case. So the list is pretty huge in which sir has actually been a public prosecutor and successfully prosecuted several cases. Sir has been our visiting faculty of SVP-NP for a long time, and also the also visiting faculty for Labasna, Missouri also, as well as Indian Law Institute, New Delhi. Without much ado, sir, I'll invite you to take the session on a very important topic, which is the BSA, the Bharatiya Sakshya Adhiniyam, which is going to be replacing the Indian Evidence Act shortly, sir. Over to you, sir.
Thank you, ma'am. Thank you very much for inviting and providing an opportunity to learn many things, sir, because this is a new thing. Everyone is trying to just learn it as fast as possible. Thank you very much. Sir, next slide, please. I have been given the topic Bharatiya Sakshya Adhiniyam. So earlier it was Indian Evidence Act. And what is the importance of witness that has been there as per Bentham, illustrious jurist, then witnesses are the eye and ear of a justice. Then again, they have said as per the Black Law Dictionary, witness is one who sees, knows, vouches for something, or one who gives testimony under oath and affirmation in the person or so and so. Then, sir, Justice Wadhwa, who has retired as a Supreme Court judge, Justice Wadhwa, Honorable Justice Wadhwa has said a criminal case is built on the edifice of evidence that is admissible in law. So that's why we are reading this Bharatiya Sakshya Adhiniyam. So it has to be, admissibility is to be seen. then for that witnesses are required, whether it is the direct evidence or circumstantial. Then, sir, what I feel is it is as important as the 7 notes. I would say this provisions of Evidence Act is like the do, re, mi, sa, re, ga, ma, pa, da, ni, just 7 notes of whether you are just thumri or pop or rap, whatever the musician are, but they must know the basics of the Evidence Act. So this is very important. And next, please. Sir, the George Herbert has said law is not the same morning and night. So it is not a static thing. It is dynamic, as we are seeing now. The entire, I would not say entire, but much change has been brought in the Bharatiya sakshya adhiniyam. Sir, an American jurist has rightly said, Louis D. Brandeis, a judge rarely performs his function adequately unless the case presented before him adequately. Sir, whether it is a defense counsel or it is a police officer or it is a prosecuting officer, they all assist the court in imparting the justice. What is the justice? Justice is to know the truth. So if you don't know the basics of the Evidence Act, then you will not be able to help the court, assist the court, and as a jurist, Brandeis, American jurist, has said, then the court will not be in position to help the justice. So this is very important, sir. Next, please. Sir, we all have been seeing every day in morning, if you switch on our TV or we turn the newspaper, what I feel, cracking of a case. Police has cracked a team of or a gang of robbers who have robbed not less than 200 persons. They have killed also. Sometimes we find a person has killed his wife and just cut it into 35 pieces, etc. Accused has confessed that I have done so and so. So these are the cracking of a case. But the most important thing is the proving of a case. In order to prove the case, we need to know the Evidence Act. Next, please. Next, please. Sir, as we all know, and since it is, I'm the third, maybe fifth, sixth, or eighth speaker. So we have a criminal justice system in world, 2 types of criminal justice system, adversarial system and the inquisitorial system. So in India, we are following the adversarial judicial system. That system is here, the prosecutor and defense, they present their case before the court. Since we are in a criminal matter, that's why I'm saying defense and the prosecutor, the 2 lawyers, I would say, they agitate their matter, and the judge, on the basis of their argument, they decide the same. So we are having the same thing here. The almost, I would not say the entire, but almost the role of a judge is a passive. Whereas in inquisitorial, that is there in the France, where the judge is also involved in the investigation itself. Sir. Next, please. So then edifice of the Indian, last one, please. We have jumped on, right. The edifice of Indian criminal justice administration system is based on certain fundamental maxim and a belief that one of these is the presumption of innocence of an accused unless it is proven guilty. Then, sir, we all know, let the 100 guilty be acquitted, but 1 innocent should not be convicted. So this is our judicial, we believe on it. Sir, sometimes I put a question to myself only, say a person who is a guilty, but for some technicality, he gets the benefit. So what I feel is that for this very reason, our judicial system has a great respect in the entire world. I would say. Then, sir, I have seen, and I'm so sorry, we all have seen the trial of Kasab also. We did have every evidence. We have the, I would say, the live evidence. Even then, the Kasab has been provided the entire full-fledged trial, and even in the wee hour, the honorable justices of Supreme Court had to awaken and decide the matter. And he was provided the lawyers on the estate expenses. So this is the beauty of our country and system, and that's why it says, let the 100 guilty be acquitted, but 1 innocent should not be convicted. Then, sir, there are 2 terms. That is, one is called burden of proof, and another one is called onus. So burden is always on the prosecution. So the prosecution means police. We will have to prove our case from all shadow of doubts. Then onus is it keeps on changing, but again, initial burden is all the police only, sir. Next, please. Then, sir, last year we all have seen there was a very so our judicial just laws, this legislation were almost 1.5 decade old. So it was failed by the government to change it. And then three things are Bharatiya sakshya adhiniyam, Bharatiya Nyaya Suraksha Sanhita, Nagrik Suraksha BNS, and this Bharatiya sakshya adhiniyam. Honorable Home Minister of Government of India has emphasized. And what I feel is nowadays, even if we need to just cook something, nowadays even the females are not asking their sasuma how to prepare it. They go for the YouTube and then prepare it. So now our system, so this I would say the encroached upon, I would own say, so internet and all these things, the electronic things has come in every field, even every walk of life. So the judicial system is not alien to it. So the need was there to change it, and thereafter it had been changed. I remember, I don't know whether Chaya ma'am is there now, Chaya Sharma ma'am, IPS, who is a special CP training in Delhi. So relentlessly, I have seen her and even typing herself. And we had worked, I had some opportunity to work with her. And then the Delhi police has prepared some books and they are coming with the books. And this has been done so. So anyway, so that's why this NPA has also come out with this program. So this is required and this has been changed, sir. Now, sir, next. Sir, what is the basic evidence? Evidence is the word which has been originated from the Latin word that is evidence or evidere. The meaning is to show clearly, to make clear sight, or to discover clearly, or make plainly certain, ascertain. So the precise meaning of evidence is to prove something to in a black and white manner. This is the Latin word from which we have just taken it. Next, man. Sir, as applicability, so now there is a change. I have a stress given on only on the changes. So as per section 1, now it extend to whole of the India. Earlier, as per the Indian Evidence Act, it used to be extend whole of India except Jammu and Kashmir. And after that disintegration, that was also there. But as per the Bharatiya sakshya adhiniyam, it applies to all the judicial proceeding in or before any court, including court martial, but not to affidavit so and so. So the scope of applicability, this word India has been now extend whole of India has been now deleted. So what I feel is after this very change, so any evidence that has been created beyond the territory of India and has been used in India or where the trial is there in the India, so that would also come as per the provisions of this thing. So that's why this India word has been added. Earlier, sir, that was there, that court martial. So it was not applicable in the court martial. Now it is applicable in the court martial also. Next, please. So now the terms document has been now redefined, I would say. And then document means I have just given in red ink that includes what is the meaning of document that is there in 2D of BSA. Now it says document means any matter expressed or described or otherwise recorded upon substance of a means of letter, figures or marks or any other means or by more than one of those means intended to be used or which may be used for the purpose of recording that matter that includes. So now this 3 words has come that includes the electronic and digital record. And illustration 6 has been added, and earlier there was not any numbering. Now it has been numbered. Now it says, sir, an electronic record on means this is the illustration that has been added after this word document of section 2D that says electronic record on email, server logs, documents on computers, laptop, smartphone, messages, website, locational evidence, and voicemail message stored on a digital device are a document. So the definition of earlier there used to be, now the IT Act was there. We had to take certain thing from the IT Act, and 22A was there, the electronic. Now this has been, I would say, the amalgamated, and now this electronic record or digital record, that is now a document. Next. Now, what is the meaning of evidence? Evidence is now defined in section. Evidence can be of two types: the oral evidence and the documentary evidence. So 2E of the Bharatiya Sakshya Adhiniyam says all statements. Now the new thing which has been added, which I have just pointed in a red, sir, that statement including a statement given electronically. So now it need not to be given physically, it can be given electronically also, which the court permits and requires to be made before it by the witnesses. So now evidence can be given by electronically also. You must have gone through the classes of Bnss, where the 530 is a basic provision, where the all things can be appeal, trial, etc. Everything can be done electronically. Now, sir, in that second part, that evidence, that is there, the documentary evidence. What does it say? That all the document, including electronic. So word electronic was already there in the Indian Evidence Act. The new things that has been done in the digital record produced for the inspection. So earlier it used to be, so document which can be produced. So as we all know, as per the basic things, so electronic record cannot be produced. In server it is stored. So that says that now documentary evidence include electronic and digital record. Next, sir.
Sir, may I, sir? So
Sir,
I would like to inform the House that see the changes that we have incorporated in the Bharatiya Sakshya Adhiniyam.
Sir.
See where we are going. Actually, society is going into a digital mode. So most of the changes you'll see that they are concentrated in and around about the electronic records, documents, and how we are going to present it before the court.
Right.
So this is the paradigm basically for the to explain the new changes that have been incorporated in the Bharatiya Sakshya Adhiniyam. So most of the point the speaker is talking about, you see that it is about the electronic evidence. What is the electronic evidence? How it may be produced, and whether we can give evidences, whether we can give witnesses through the electronic means or not. You'll see all changes here, which Bharatiya Sakshya Adhiniyam incorporated. Thank you, sir. You may continue.
Sir, then in section, so I have there are some little changes in comparison to Bnss and this, but this is, since I have said it is an adjective law, it has a repercussion, because without knowing all these things, everything will be. So next, I have just incorporated a certain judgment also, where the importance of Evidence Act we can just appreciate. Now, in section 2E, the term "if man has a certain reputation" is a fact. So this was already there. So since I'm appearing before the Honorable LG also, where the such type of cases, the externment, etc. are there. So what we write, that this person has been in the habit of doing all these things. So he has a certain reputation. So just see, this very particular person has a certain reputation that has been omitted. So it's a I would say very brilliantly it has been, if a person has a reputation, but it keeps on changing. So if a person has a reputation, it does not mean he's a thief or etc. So this fact, from the definition of fact, a man has a certain reputation, has been omitted. Now there is a new provision that has been added in section 2.2 of the Bharatiya Sakshya Adhiniyam, wherein it says that when the definition, the word and expression used herein and not defined, but defined in IT Act, the Information Technology Act, the Bharatiya Nagrik Suraksha Sanhita, etc., shall have the same meaning. So if it is not there, so we can take the help of the Information Technology Act also. This is a new changes that has been done. Sir, next. Next slide, please, sir. Sir, now there is, we all know there is a provision, doctrine of res geisha. So something has got nothing to do with this. Directly, if you say something like, as we all have seen, someone has murdered, but a person is just saying that fleeing away with some knife. So independently, it has got nothing to do with the case. But if you see with other things, then it has a bearing in the case. So that is called res gesha. So now section 6 is now section 4 in Bharatiya Sakshya adhiniyam, where it has been the I would say this aura has been, I would say the definition has been widened. So what does it say? Earlier it was there that facts which though not in issue are so connected with the fact in issue. So that was there, the fact in issue that needs to be proved. Now that says in Bharatiya Sakshya adhiniyam, not only connected to the fact in issue, but or a relevant fact. So if it has some connection with a fact in issue or relevant fact, then it is a relevant fact. Sir. Next. Now in rest gesha also, so there's some changes are there, that earlier the word was there vakil, that has been now replaced by the word advocate, then proved was there. So this was basically a typographical mistake that has been now taken care of, and this has been now corrected as provided. Man, now it is gender neutral. It is the word person is there. Ravish word has been substituted by the word rape. And the section 21 words advocate has been replaced for the other words barrister, vakil, pleaders. These all terms were there in the English term. Now only advocated there. Now in section 22 of BSA of old 24, the word coercion has been now added. Next. Now, it is very important whenever I see, you must have been given lecture on now trial in absentia. Whenever I feel, had it been there, then we would have been in position to just proceed against Dawood, who is sitting somewhere in Pakistan, etc. So now the basic change which has been brought in Bnss, that says in absentia trial is also possible. So in section 24, earlier 130, that says about the joint trial. And a confession of a person can be used against the co-accused unless and until and subject to the joint trial. So now this says, as per the new act, new section 24, old is of section 30 of the Indian Evidence Act, that says if a person who has absconded, but he has confessed something, so his evidence, his confession can be taken and used in the trial. So a person who is inactually, he is not facing the trial, he has absconded, he is a proclaimed offender, or he is a absconder, but his evidence can be, confession can be taken. So what it say, the section 24 explanation has been numbered and new explanation 2 has been added. So what does it say? Explanation 2 of section 24, a trial of a more person than one held in absence of the accused. Absence of the accused, or who has absconded, or who fails to comply with the proclamation issued under section 84 of the Bharatiya Nagrik Suraksha Sanhita shall be deemed to be a joint trial. So even if physically, in fact, he is not facing the trial, but it will be deemed to be so and so. It can be used. Next. Now, sir, many of you must have been to Supreme Court and the High Court also. So we have seen whenever we place before any copy of the judgment before the honorable justices. So what does this? They never see that thing. They instruct their court master or the staffs over there. They took out the book and they see the book, and from the book only they refer the things, sir. So now there are 2 sections that have been replaced on the earlier one. Earlier was 37 and 38. Now it is 31 and 32. It says that the e-book, website, official gazette in electronic or electronic are innocent. Now we can save after this very the repercussion. What I feel is now we are in Delhi in 47, someone is 50 degrees centigrade or section. So we are able to, through this very legislation, now no need to go for the book in physical form. So if it is there in the electronic mode also, so that will have the same bearing as if it is a SCC or All India Reporters judgments are there. So through this, we can save the environment also. We can save our tree also. This change is a very... Now the tribunal order is also covered under section 35. Next, please. Now, there was two sections earlier, section 45 and 45A. 45 was for basically for the expert, and 45 was an electronic expert. So now this has been included in one section, that is section 39. One is a section, old section 45, and 45A is now section 35(2). But the one, or I would say the three, the words have been added. This says the when a court has to form an opinion upon a point of foreign law or a science or art or any other field, or as the identity of a handwriting or fingerprints or opinion upon a point of person, especially skilled, foreign law, art, or any other field. So the word is there, any other field. So I was just searching at one point of time when I had joined as a prosecutor. So I used to laugh, why this person is saying I am MSc, I am PhD, I have appeared before the court so many times. On my evidence, the court has given judgments, etc. So in order to just, why you used to give this very evidence that this is required as to prove the person is an expert. So now one judgment, there was something was there like polo, etc., polo bat. So we had lost the case only on a ground the person who had appeared is not covered under section 45. So now it has this three words had changed, I would say, the widened it. So it is any other field. So they are expert. Next. Sir, this is when in a proceeding, the court has to form an opinion on a matter relating to the information transmitted or stored in a computer resources or any other. So in order to earlier also section 45A, now it is 39(2), we will have to just go on the section 79A of the Information Technology Act, where the definition of expert is there. So for the purpose of the subsection, examiner of electronic shall be then expert. So the expert, next please. Sir, this section 79A says the central government, in precise, I would say, because we are running in sort of time. So it says that any body or the lab which has been notified in official gazette by the central government are the expert. So the word says the central government to notify examiner of the electronic evidence. The evidence, the central government may, for the purpose of providing expert opinion on the electronic form evidence before any court or other authority specified by notification in the official gazette by the department body. So who can be now notified in official gazette? Any department, body, agency of a central government or a state government as an examiner of electronic evidence. For explanation, the electronic form of evidence means the information of a probability value. So a person, what I say, these all things are required. Unless and until they have been notified, they are not expert. Next, please. Sir, these are the labs which has been notified by the government, but there are certain more also. Because I was just going to. So these are the CFSL Hyderabad, CFSL Lodi Road, New Delhi, FSL Gujarat, Ahmedabad, that is RFSL Dharamshala, FSFL Bangalore. These all are notified by the central government in official gazette. So we will have to take their help whenever it is required. Next. Now, sir, section 52 of Bharatiya sakshya adhiniyam, earlier it was section 57 of Indian evidence. The court shall take. It is a mandate. There is a provision, and earlier it was section 56, now it is 41. 51 things admitted need not to be proved. So we will have to prove only disputed fact. A fact which is already admitted, we need not to prove it, which can be. So this section says the court shall. So there is no discretion. Court will have to take the judicial notice of certain things. So now this has been further widened. I have said, sir. So all laws in force in the territory of India, including. So this new red words are there. Section 52(1) subclause A, sir. Laws having extraterritorial operation. So there are certain laws which is applicable outside also. So this the court will take the judicial notice of those extrajudicial operation also. Next. Then, sir, there are two things, that is the primary evidence and the secondary evidence. So primary evidence.
Sir, may I, sir? Sir,
Sir,
I
please.
would like to inform all participants here that this is the major change that sir is going to talk about. It's a primary in primary evidences we have a 4 explanation which are completely new.
And had been added, right?
In my opinion, that they will transform the electronic evidence the way we are the way we are presenting before the court. Please, sir, carry on, sir.
Thank you. Sir, now this 4 explanation, 4, 5, 6 and 7 has been added in primary evidence. Sir, as we know, there are 2 types of evidences, primary evidence and secondary evidence. In primary evidence, earlier there was 3 explanation, now the 4 further explanation has been added. Sir, the explanation number 4, where an electronic or digital record is created, is stored, or such storage occurred simultaneously or sequentially or in files, each of the files is evidence. So, is a primary evidence. So, if anything which had been stored, and subsequently, sir, we have seen, because I have been associated with many investigation also, we have seen, sir, when we had gone to the person, they have said we did have only 15 days recording, and now it is effaced. No, we can't provide. So, if it had been simultaneously stored in some other places simultaneously or sequentially, it has been multiple files, then each of the file is a primary evidence. Then, sir, explanation 5, where an electronic or digital record is produced from a proper custody, such electronic and digital record is primary evidence unless it is useful. So, if it has been produced from a proper custody, then it will be a primary evidence unless it is disputed. Then, sir, section 6, explanation 6, sorry, where a video recording is simultaneously stored or electronic form and transmitted and broadcast or transferred to another, each of the stored recordings. So, if this very particular which lecture I am just giving, or we are sharing our experience. So if it is stored simultaneously in different places, then each of them is a primary one. So this is a very excellent initiative through which we will be able to save many cases. Sir. Explanation 7. Where the electronic or digital record is stored in a multiple storage spaces in the computer resource, each of the such automatic storage, including the temporary file, is a, so even the temporary file which has been created and stored, then it is also a primary evidence. Sir, I will like to give an example. I don't know what will be the fate. So I am dealing on a case as a special PP in one of the matter of Dhananjay Singh MP, wherein one maid servant was killed. So there is an allegation against her wife. So she herself has installed the CCTV footage and this beating, etc., the atrocities, the how she was beaten, this entire thing was recorded in the CCTV cameras, sir. Then what we have done, our investigating officer, he had seized all the DVRs. Now, sir, after it matters is of 13 or 14, most probably it is of the 13. So when the evidences, the terms of evidence has come, so the DVR itself is not able to be displayed. Now, sir, the problem is then we have to just go by many other things also. So these are the things which needs to be. So had it been at that very time, so we could have given to some other places also. Next, sir. Section 58, that is the secondary. So we have talked about the primary, now it is secondary. So if some evidences cannot be given of a primary, then prosecution can give the secondary evidence in lieu of the primary evidence. So earlier there was the 5, now 3 further have been added. So now says that secondary evidence can be proved by oral admission. Then, sir, written admission. So there can be oral if there is a issue between A versus B, and A has produced certain things in secondary evidence and B admits it orally, even then it is a secondary evidence. It is proved. Or he may give in writing, that is also a written admission. And then third is the evidence of a person who has examined a document, the original of the consist of the numerous accounts or other document which cannot conveniently be examined in the court, who is skilled. So what I had said, Sri C.P. Singh is an expert, Dr. C.P. Singh. So had it been there, then we would have been in position to say कि he is a person who has examined all the DVRs and now it cannot be brought. So this is a secondary evidence which could be. So this is also an welcome sir changes which has been brought, which will give of a great help in future. Sir, next. Then 61 BSA is a new provision. It is not there. It is not there. Then 61 says nothing in this adhiniyam shall apply to deny the admissibility of an electronic or digital record in evidence on a ground that it is an electronic or digital record or such record shall subject to the section certain. Now, sir, this says the criteria which sir had just mentioned, that the thing which has to be taken care of is the section 63. That is one of the most important changes. So, and I would say that is now it has been widened of earlier 65B. So, if it fulfills the condition of section 63, then its admissibility will not be denied. So have the same legal effect, validity, or enforceability as the other document. So it will be a document if it fulfills the condition of section 63, then as per the section 61, its validity cannot be challenged. Next. Section 62, that says that the contents of electronic record may be proved in accordance with the provisions of section 63. In order to further buttress it, so this has been added also, like section 61, it says it can be proved only may word is there. So earlier in section 61, shall word is there. So here, just a minute. मैं lecture दे रहा हूं, पर काट रहा हूं आपको. Then this says it can be proved as per the section 63. Sir. Next, sir. Now, section 63, it is very important, sir. Notwithstanding. Earlier also, this word is notwithstanding. So this is a non-obstanta clause, in spite of anything. So whatever is there, since it commences with the word notwithstanding, anything contained in this adhiniyam, any information contained in electronic record which is printed on a paper, stored, recorded, copied in optical or magnetic media or semiconductor memory which is produced. These are the new words, semiconductor, produced by a computer or any communication devices, otherwise stored, recorded or copied in electronic herein after computer output shall be deemed to be a document. So it will be a document. If the condition, so now it says if the condition mentioned in section are satisfied in relation to the information or computer in question shall be admissible in any proceeding without further proof or production of the original. So what the Anwar PB has said, so this certificate under section 65B, which is now section 63, would be required only in case of secondary evidence. So if primary evidence has been collected, like, so we have just seen as sir has said, the four explanation has been added. So these all are primary. So if it is there, then section 63 certificate will not be required. Otherwise, it will be required. So as the Supreme Court consistently, High Court of different states have consistently stated, this is required only in case of secondary evidence, not in a primary evidence. If we have been able to just collect or seize the DVR itself, NVR itself, then a certificate is not required. So that's a without further proof of production as evidence of any contents of original or any fact stated therein of which direct evidence would be admissible. So it will have this thing. So we will have to prove the condition that is there in the section 63A. Sir, I remember one of the learned principal district and session judge had said why this provision had been added. So very rightly he had pointed it out while in some informal discussion we are doing. So he said, Atul, because we give this provision is there, basically we give this has been copied from laptop, make so and so, then the number, etc. After using the another computer, this thing, and it had been stored or transferred in a, say, like a pen drive having description all of that. So we have given the description of all the things. if you want to check it, you go and check it. This all will be there. So basically, concept what sir had said. So it's very appealing to me also. The section, either it is a section 65B or section 63. So if you want to check, it is there. We have already given all the particulars, detail of the computer or devices used in collecting or taking out or retrieving. So these all things are there. You go and please check it. So now this has been further, I will say, strengthened by introducing hash value also. Next, please. Then section 63(4) is very important. So that says, if in any proceeding where it is desired to give a statement in evidence by virtue of this section, a certificate doing any following thing shall be submitted along with the electronic record. So electronic record itself is not to be said, it has to be with a certificate. So at each instance where it is being submitted for admission, namely identifying the electronic record containing the statement and describing the manner in which it was produced. So using this very computer from this very server, we have taken it out. So we will have to go the path through which it has come, giving such particulars of device involved in the production of that, giving such particular of any device involved in production of the electronic record as may be appropriate for the purpose of showing that the electronic record was produced by the computer. So these things we need to now, sir. Hats off, I salute all the framers who has framed it. So they have given, as first time in scheduled is there, they have given this format, and we will have to fill the format itself, sir. So next, please. Dealing with any matters to which the conditions mentioned in subsection relate and purporting to be signed by the person in charge of the computer. So I feel this is also maybe nowadays we are planning. So it has to be now videographed by the IO, etc. So IO would be able to give the certificate in regard to what he has done. But if it is given in a server, and if certificate is required to be given, so I don't think it will be suffice of the IO, because the law says purporting to be signed by a person in charge of the computer. So he is not the in charge of the computer. He is not the in charge of the server. He's an IO he's in charge of the very particular case. So we will have to think of computer and communication devices and the management of the relevant activities, whichever is appropriate. And so this is not or. Then the second part, which I will be dealing subsequently in other presentations, sir. So another slide is there that says it has a two part. So it does not say or, it says and. So the person who is giving his certificate needs to be given along with the hash value, and then and. That's why I have written it in red. An expert shall be evidence of any matter stated in the certificate, and for that purpose of this subsection, it shall be sufficient for the matter to be stated to the best of knowledge and belief of the person stating it to be certificate specified in the schedule. So this says, as per this very section 63, 4C says it has to be given as per the certificate specified in the schedule that is appended with the Bharatiya sakshya adhiniyam. Next. Now this is certificate, sir, prescribed certificate as per the schedule, sir. So you all must be having, sir. Next is also the same certificate I have. So this certificate is quite clear. The certificate part A, it is in two parts to be filled by the party. So it has to be in two parts. Part A is filled by the party. Then he will have to give his name, address, etc., and IMI number, serial number, everything, make, model, everything has to be there. And the logarithm through which hash value he has taken out. That has to be SHA 1, SA 257, MD5, and others. So we will have to just give these things through which logarithm we have taken out the hash value that needs to be mentioned. Next. Sir, this is part B, just on the top itself, to be filled by the expert. So this certificate would not be valid unless and until it is also filled by the expert. So it has to be by the person who wishes to give the electronic evidence, secondary evidence. He will have to give his own certificate, and that has to be countered, I would say, the forwarded, or has to be from the expert also. Next, sir. Then, as we all know, there are two ways to, there are oral and documentary evidence. Two types of evidences are there. The oral evidence, that is a chapter 4 of the Evidence Act I have mentioned, the BSA, that is 54 and 55. So a person who has seen something or who has perceived from the five sense of organ. So if somebody, the hearsay evidence is not admissible, as we all know, and basically we are on a documentary evidence. Chapter 56 to 93 is the oral evidence. As I have said, it has to be necessarily direct and no hearsay will be. And then documentary evidence can be proved by two way, that is a primary evidence as well as the secondary evidence. Sir. So the primary evidence, the contents of electronic record may be proved in accordance with the provisions of section 63. This is about the, which we have just discussed about the electronic evidence. And this says any information contained. So if secondary evidence we have to prove, then, so the, if this very book or particular any book is required to be given, this is document. So if we have placed before the court the document or a deed or anything, and court can inspect it, then it is a primary evidence. But we cannot produce something is already in the server. So in that very situation, we'll have to take out the in a pen drive, etc. And then we go there and we will have to follow the dictum, the condition that is there in section 63. Sir. Next, please. Then electronic record primary and secondary requisite certificate section 6 would be required only in case of secondary evidence. Just we have discussed, sir, but not in a primary evidence. Sir. Next, please. Sir. Sir, these are the, I have just stated, this is a journey of section 65 of Indian Evidence Act, sir. Sir, why I have just given this topic as a journey? Because we have seen a case, that is Parliament attack case, sir. Afzal Guru, Navjot Sandhu alias Afzal Guru case. In that very case, sir, the entire things was produced, CDR, etc. But the certificate was not there. Certificate was not given there. In that very situation, the officer who had gone there of the MTNL, he has given all the things. This is the correct one. And oral admission, and on the basis of which the court had adjudicated and convicted the person, and then conviction had been given. So this judgment was passed on 5th of August 2005. Then this very period of section, sir, back, sir, this very another judgment, that is of Anwar PB versus PK Basir and others. This judgment has been adjudicated upon by the Honorable Supreme Court by the larger bench of the 3 judges, wherein they have said, they have set aside the overruled the judgment of Navjot Sandhu. So they have said the crux of the Anwar PB, it overruled the larger than 3 men has said, to that extent, what the court has said, to that extent, the statement of law on the admissibility of secondary evidence pertaining to the electronic record, as stated by this court in Navjot Sandhu case, does not lay down a correct legal position. It requires to be overruled, and we do it. So they have specifically overruled the earlier judgment of Navjot Sandhi. So certificate is required because it is a non-obstanta clause. It commences with this thing, not the, so certificate is required. So it cannot be substituted by the oral evidence. Then it has stated that if electronic record is used as a primary evidence under section 62 of the same is admissible in without compliance. So they have said if it is a primary evidence, it is not required. But if it is a secondary evidence, that it has to be with certificate under section 65B, which is now section 63 for C. So these 2 dates are very important. So during this very period, so what has happened? So during that very proceeding, so as per Anwar PB judgment, that says the date on which this has been retrieved, this has been created, the certificate needs to be of that particular date. It cannot be given subsequent dates. So if the defect has been subsequently found, then this cannot be rectified. So on this very basis, so this very duration, so state has lost many cases. I remember one case of Ankur Chawla, one lawyer. There was a sufficient evidence against him, but certificate under as per the provision 65B was not obtained. So the Honorable Delhi High Court has said now, as per the dictum of the larger bench, you cannot give this certificate of a subsequent date. It had to be of that particular date which you have not obtained, and subsequently you cannot obtain. So during this very period, we have lost many cases on the technical issue of is decided by Anwar PB. Sir. Next, please. Sir, as we, this is the judgment, Safi Muhammad versus State of Himachal Pradesh. Sir. This judgment was there wherein the Honorable Supreme Court of India has invited MHA to just, which we have already now seen in section 105 of Bnss, that says, sir, why all the procedure of seizure, etc. should not be videographed. So they have invited the MHA and directed MHA to have a discussion among all the police department, and let there be any procedure through which we can just record or videograph all the proceedings of seizure, etc. So that was the issue. Then, sir, I feel I was also part of it because it's some discussion, sir. So we have shown, so many things are there. Suppose if a document is there, electronic evidence is there. So this is in the custody of some person against whom I am fining. So obviously he will not give the certificate, and I will not be in position to give it. And the storage is the problem. So many things were there. So the Honorable Supreme Court has said that this section 65B is a procedural aspect. So if there is a conflict of the substantive act and the procedural aspect, then procedural aspect can be relaxed. So on this analogy, the Honorable Supreme Court has stated the applicability of the procedural requirement under section 65B4 of the Evidence Act of furnishing a certificate is to be applied only when such electronic evidence is produced by a person who is in position to produce such certificate, being in the control of said device and not of the opposite party. So if I don't have any control, so how can I produce it? So this was the question, and this has been decided in 2018 volume 2 SCC 801. This is Safi Muhammad, but of course it has been set aside now. Now, sir, next one. So that's why I have said this is a journey, sir. So then Honorable Delhi High Court Division Bench has beautifully, they have illustrated, which is now, I would say, the new law as per the Arjun Pandit Rao Khotkar, sir. In Kundan Singh judgment, this judgment was of 14th of November 2015. Sir, as I have said, sir, this is law is not static, it is dynamic. It keeps on changing. Everything. That's why I have said it is not in the same morning and evening there is a change, sir. So the Anwar PB partly overruled the earlier decision. What they have given, sir, no, it can be subsequently by using like 91, section 91 of the CRPC, we can summon the other document on the same analogy. We can have the certificate also on subsequent date. So what the court has said, the division bench, that the Anwar PB partly overruled the earlier decision of the Supreme Court on the procedure to prove the electronic records in Navjot Sandhu, holding the section 65B is a specific provision relating to the admissibility of the electronic records, and therefore production of a certificate under section 65B is mandatory. Anwar PB does not state or hold that said certificate cannot be produced in exercise of the powers of the trial under 311 CRPC or at the appellate stage under 391. This is the power of appellate court, sir. Evidence Act is a procedural law, and in view of the pronouncement of Anwar PB, partly overruling the Navjot Sandhu, the prosecution may be entitled to invoke the aforesaid provision when justified and required. So, like Ankur Chawla and all case which we have said, that very year 2005 to 2014, we have lost many cases due to. Then they have given a via media or a way out which can take care of this Anwar PB, sir. Next, please. Then, sir, this is a judgment that had been decided on 18th of July 2017 by the Honorable Supreme Court. This is Sonu alias Amar versus State of Haryana. This is reported in 2017, Volume 8, SCC 570. That the crux, there was a question how it is to be retrospective or prospective, sir. Then they say if the judgment in the case of Anwar is applied retrospectively, it would result in unscrambling past transaction and adversely affecting the administration of justice. As Anwar's case was decided by a 3-judge bench, propriety demand that we refrain from declaring the judgment would be prospective in operation. We leave it open to the decided in appropriate cases by a 3-bench judge. So they have said, so this very period of 2005 to 14, we have investigated many matters. So just ticklish thing, so we would be losing this thing. So they have, the Supreme Court was very anxious, was curious to do it. But since they have said we are a 2-judge benches and Anwar PB is a 3-judge benches, so we cannot do it. So they have just left it, and that has been done in the another 3-judge bench of Arjun Pandit Rao Khodkar. So they have said we leave it open to be decided in appropriate case. So doctrine of prospective applicability or retrospective applicability, that was the question, and that has been left in this case, and this has been decided subsequently, sir. Next, please. Sir, this is Union of India and others versus Commodore Ravinder V. Desai. This judgment is of 17, now it is of 18, sir. 18th of July of April 2018. This is reported in 2018, volume 16, SCC 273. So here, again in court martial or some proceeding was there. So secondary evidence was there, but despite repeated requests, the certificate could not be produced. Then what the court has said, we are in agreement with the aforesaid finding. The learned counsel for the appellant rightly argued that non-production of the certificate under Section 65 of the Indian Evidence Act on an earlier occasion was a curable defect, which is cured. Law in this behalf had been settled by the judgment of Sonu alias Amar versus the state of Haryana. We have just said. So they have said this is a curable defect. So if it has not been done, then subsequent stage this can be cured, and technicalities some cannot be given. So this is, again, I have said the journey, the train has passed further, and they have said no. Earlier they have said no, it has to be of the same date. Then Kundan Singh said no, subsequently also by using 311 or 391 or 91 CRPC, this can be produced. So now the Supreme Court has started saying no, this is a curable defect, it can be cured, and that has been done. So it was done in this very case, sir. Next, please. So this is a state by Karnataka Lokayukt Police Station, Bengaluru versus MR Hiremath. This is judgment of 1st of May 2019. Earlier was 17, 15, 17, 18, then 19. Then the Honorable Supreme Court has said, in this way, this is reported in 2019, volume 7, SCC 515. In this very case, I have just inserted this very portion of as it is, the quotation of the court. Having regard to the above principle of law, the High Court erred in coming to the conclusion that the failure to produce a certificate under Section 65B of the Evidence Act at the stage when charge sheet was filed was fatal to the prosecution. The need of production of such certificate would arise when the electronic record is sought to be produced in evidence at the time of trial. It is at that stage that the necessity of the production of certificate would arise. So in this very case, what had happened, the learned counsel has argued, so whatever the document you have produced, the evidence you are willing to produce is without the certificate. So if certificate is not there, then it is useless. So this evidence can't be used. So on this very ground, they were discharged or the matter was quashed. The matter went to the Supreme Court. Supreme Court had said, no, at the stage of filing of a charge sheet, it is not required. It can be given subsequently also. So the decision at this stage, the charge sheet stage, it has not been filed, cannot be a good ground to quash the matter. And they have set aside the quashing matter by saying that it can be produced subsequently. So I have just incorporated the judgment that says this is a journey wherein step to step they have gone, and finally it has been decided in Arjun Pandit Rao Khotkar. I believe the same, next one is the same judgment. Next, please, sir. So this is Arjun Pandit Rao Khotkar. This is the latest judgment, which is in Delhi, sir, versus Kailash Kusan Rao, Gorantyal, and others, the Honorable Supreme Court on this is a 3 judges judgment of 14th of July 2020, wherein they have said, so it has clarified all the confusion which was cropped up from Navjot Sandhu to this Anwar PV, and then many other Hiramath, etc. They have suggested something. But this judgment has clarified as it is a 3 judges judgment. The certificate not required if this is the crux of the judgment. Certificate not required if the original document is produced. 1. Certificate under 65B of the Evidence Act condition precedent for admissibility of the electronic evidence. This is a condition precedent. Then application to be filed in the court if the person authority refuses to give the. So if what the Safi Muhammad has said, if it is not, he is not in control to produce it, then the court has said the concerned person or other authority will move the application under 91 seeking direction from the court. Yes, you please direct X in whose custody this document is there to produce the certificate. So this is the way they have suggested. Application will be filed by the court if the person or authority refuses to give the certificate. Then, sir, a stage at which the certificate can be filed. They said subsequently also it can be filed. It was further held that till the hearing of the trial is not complete, the requisite certificate can be directed to be produced by a learned judge at any stage so that the information contained in the electronic record can then be admitted and relied upon. So they have said no, it can be subsequently till the termination of trial, like 311 CRPC. What does it say? So a person can be called, resummoned, or who is an important witness, he has been left, the police has not cited him a witness, but court has come to know, yes, he is an important witness, then till termination of trial, till signing of the judgment, judge can call him. So on the same analogy, they have said, yes, till termination of trial, this certificate can be produced. Sorry, sir. So this has already, and the natural repercussion is this have overruled Safi Muhammad, upheld Kundan Singh, and modified Anwar Sivse. Sir, the direction issued by the Supreme Court to the cellular and the internet providers to earlier it used to be, so if any CDR is required. So the maximum period of preservation was earlier 1 year. So direction was given to enhance this very time, sir, increase this time. That has been done. Now it is 2 years. Sir, I have added that certificate direction of the government also. The Supreme Court also directed the appropriate rules and directions should be framed in exercise of the Information Technology Section 67 of IT Act, and also framing suitable rules for retention of the data involved in the trial of an offense, their segregation, rule of chain of the custody that has been now brought in. Now we file the charge sheet as per the Bnss 193. The custody of the electronic record is to be mentioned in the charge sheet itself, sir. Then rules of chain of custody, stamping and the record maintenance for the entire duration of the trial and appeals, and also regard to the preservation of the metadata to avoid the corruption. Likewise, the appropriate rules of preservation, retrieval, and production of the electronic record should be framed. Section 67C2 provide punishment. So if any violation is there, then it is a penal offense, sir. So in pursuance of this, next please, sir. Sir, outcome of the judgment, Supreme Court through this judgment in the case of Arjun Pandit has brought abundant clarity in the conflicting views of the and practical applicability of the mandatory requirement Section 65 of the Evidence Act for establishing the admissibility of an electronic evidence which had become a mere formality in certain circumstances, notably looking at the practical standpoint, the much needed clarification provided by the Supreme Court on the option. So this has been clarified from all angles, sir. Next, please. This judgment is of Honorable Supreme Court. This is much letter of the Anwar PB. So wherein we can see what the benefit we have got through that judgment. In this very case, sir, after 6 years of the trial, 6th year of a trial, the application was moved by the prosecution to bring the Section 65B. Then the Supreme Court, up to the High Court, on the basis of the delay in proceeding, etc., they have turned down the application. What the Supreme Court has said that needs to be read. That's why I have incorporated it, sir. This is of 6th of November 2023. Coming to the issue as to the stage of production of certificate under Section 65B of the Act is concerned, this court in Arjun Pandit Rao Khodkar's case, Supra, held the certificate under Section 65B of the Act can be produced at any stage if the trial is not over. Fair trial, so they says the fair trial, it has to be, now fair does not mean it is only fair to the accused. It is fair to the complainant also. Now the doctrine of victimology is there. The victim has also a role. And ultimately in criminal matter, the society is the victim, sir. That's why the state fights the case. Every FIR case, sir, it is a state, the public prosecutor who fights it. The fair trial, it is a concluding part. So the fair trial in a criminal case does not mean that it should be fair to one of the parties. Rather, the object is that no guilty should go scot-free and no innocent should be punished. So let 100 innocent be acquitted. So they have said, now there is a change, victimology is there. They said the guilty should not go scot-free for some technical reasons also, sir. And no innocent should be punished. A certificate under 65B of the Act, which is sought to be produced by the prosecution, is not an evidence which has been created now. It is meeting the requirement of law to prove the report on the case. So the Honorable Supreme Court has further, in order to just justify their judgment, they have said it is not a document which is now being created. It is already there. It should have been taken on a file which has been unfortunately not taken. So it can be now, sir, I remember the many judgments are there. That judgment says if there is sometime the IO does some wrong unwillingly or due to lack of knowledge, they commit some irregularity or some illegality also. So, and sometimes willingly they do something to just help out the accused. In that situation, the Honorable Supreme Court had said, no, in that very situation, if the case is otherwise proved, so any illegality even or irregularities on the part of the IO cannot be of any help to the accused. So on the same analogy, what I feel is they have said fair trial in a criminal does not mean, so it is not a document which is now evidence is being created. It was already there, but it could not be produced at the proper time, and time is there as per the Arjun Pandit Rao Khodkar. Yes, till termination of trial, it can be said, though 6-year time is not a time, it cannot be rejected on this very ground. On this, so this is a result of this Arjun Pandit Rao Khodkar's statement. Next, please, sir. Then this is a case, again, I would say I am contradicting myself. This is the 4th May 2022. In this very judgment, the Supreme Court has turned down the death penalty which was awarded and confirmed by the High Court on a ground that Section 65B was not there. That the Supreme Court has said the electronic evidence produced before the High Court should have been in accordance with the statute and should have been complied with the certification requirement for it to be admissible in the, this is Ravinder Singh alias Kaku versus the State of Punjab. This is 4th May 2022, Honorable Supreme Court. Death sentence was set aside. Then, sir, as rightly stated about oral evidence in place of such certificate, as is in the case of present matter, cannot possibly suffice. The Section 65B4 is mandatory requirement. And on the ground of non-availability or non-production of this thing, the Supreme Court has set aside the death sentence itself. So we, as per the new law, So this can be given at any stage as per, because the judgments are already there. So some act or legislation or section would be redundant. But if it is already going on, as per the reply, it will go on in the same manner. But this will always be helpful, because the judgment, through this judgment, we can say, sir, we have missed to file it, and now we wish to place it filed. Sir, we have already covered this thing, electronic records being the more susceptible to the tampering, alteration, etc., etc. So that's for this very reason, now the framers have come out with a more scientific way, just to make sure there is no tampering or I would say interpolation in any record as hash values here. So I'm not a science student, but I have been told, or what I could read from this thing. And thank you, NPA, that provided me to just read again, just to prepare myself to face you all experienced person. They have said, sir, if hash value is taken of a document, so any document is created, then hash value is already there. So this input hashing is equal to hash value. And if any color is changed, if comma, full stop, any of the word is changed, then the hash value would get automatically changed. So if hash value we have given, and the court can check the same with the help of hash value, if there is no change, it means there is no interpolation. Right, sir? So this, now we are on a more accuracy. That's why I have said hats off to the framers who have brought this. Next. We have already dealt with, this is condition of section 63 at the time of creation of the electronic record. So there are the certificate. This certificate itself is clear. We will have to fill the certificate. So, and the certificate incorporates all these conditions there. So obviously we will have to read this thing. But since law itself is very clear as per section 63, that if it is as per the scheduled, the certificate, then it is a clear one. Next, sir. Then this says the purpose of a certificate is to satisfy the condition laid down in subsection 3 of section 63. The certificate is to be executed, signed by a person occupying a responsible position in relation to the device through which such data. So this needs to be somehow addressed, because the person, the word says the responsible person. So there has to be like the nodal officer, they come from the CDR, they bring the CDR and appear on behalf of the subscriber company that I am so-and-so responsible person, and it was taken out by me using the code which was provided, and this, there is no interpolation, etc. So this certificate needs to be from. Next, sir. In this very case of call record, it was the case, the High Court of Delhi, while appreciating the reliance placed on the prosecution upon the call record, observed that computer-generated electronic record is evidence admissible if the proved in the manner specified by section 65B. That was their digital camera photograph. They nowadays it needs to be along with the earlier. It used to be they used to bring the negative. And being a prosecutor, we have examined many persons. So we have said we have brought the negative, and this is positive placed on file are corresponding of this negative. So now it is photographs are taken through digital camera, and camera is now computer as per new definition. So 65B will be required. Proof of email, again 65B will be required. Next, sir. Sir, I don't know how many of you are an police officer in Delhi. We see many times whenever the police officers come to depose as a witness, they are not allowed. They refresh their memory. They start reading much as if he is preparing for some examination, etc. So this is a judgment, K. Yarappa Reddy. This is of Honorable Supreme Court of India in 2099. They have said, sir, while under examination also, you have the right to see the file and answer to the court, sir. So this will be of some great help to all police officers also. In Delhi, we are saying so. So if you've missed something, then you can request the prosecutor or the court also. So I would like to read this very particular, this is 2000 Criminal Law Journal, page 400, State of Karnataka versus K.R. Appa Reddy. What the beautifully the honorable justices of Supreme Court has, I would say, understood the position and the practical aspect of a police officer. They have said PW 15 sub-inspector was asked during the examination in chief what about what happened on 30th of January 1982, and he wanted to check up his records as he could not remember without refreshing his memory. But then the defense counsel seriously objected and wanted the court to disallow him from looking into those records. It is not clear whether the said objection was upheld or whether 1515 was allowed to check up with the records of investigation. So it is clear the evidence process was on. Next, sir. Sir, the court cannot, this very important thing is the trial court cannot overlook the reality that investigating officers comes to the court for giving evidence after conducting investigation in many other cases also in the meanwhile. This is very fact, sir. Then say the evidence giving process should not book down to the memory test of the witness. An investigating officer must answer. This is very important for you all police officers are there. An investigating officer must answer the question in the court as far as possible only with the reference what he had recorded during the investigation. Such records are contemporaneous entries made by him. Hence, for refreshing his memory, it is always advisable. So this is the advice is being rendered by the Supreme Court. Always advisable to that he looks into those records before answering any question. So if any question is there and who other had signed this as a witness, then you may say, sir, now it is due to a lapse of time. I would like to see the documents. You can request the court. I would like to see the seizure memo. And then after seeing, you can always this thing. So this very judgment I have just incorporated for practical aspect that this can be of great help to you while you appear as a witness. Sir. Next. Next, please, sir. Sir, sorry, this has been repeated, I believe. We may escape this one. Sir, back, please. This next one. This one. No, sir. Next. Next, sir. There is some government order. Sir, this is a judgment of Honorable Supreme Court of India, wherein they have said, all we know, there is section 134, head is not to be counted. It is the quality, not the quantity of evidence is required. Even a single witness is sufficient. So if our electronic record is very man may lie, not the circumstances. So if we work hard to just produce or present the evidence electronic, so on this very basis, there can be a conviction. So this court has said if plurality of the witnesses would have been the legislative intent, cases where the testimony of a single witness only could be available in number of crime offender would have gone unpunished. It is the quality of evidence of a single witness whose testimony has to be tested on the touchstone of the credibility and reliability. If the testimony is found to be reliable, there is no legal impediment to convict an accused on such proof. It is the quality that is very important. It is the quality and not the quantity of evidence which is necessary for proving or disapproving a fact. This position has been settled by series of design. They have said, so even if we don't need head is not to be counted, that there are 5 witnesses, sir. Like a single witness, cogent, reliable, trustworthy, there can be a conviction. Next. So this is a certificate. This is a direction I would say by the Government of India, 21st of December 2021, wherein they have directed the mobile subscriber that it has to be 2 years. So last word is there, the scrutiny security condition on your my right side is there on the table 2, last one. The licenses shall maintain CDR, IPDR for the internet, including the internet telephony services for a minimum period of 2 years. Earlier it was 1 year, now it is a 2 years. You must be knowing, sir. Just I have brought for some of person might not be knowing. So now CDR can be obtained even not only up to 1 year, rather it has been enhanced to 2 years. Sir. Next, please. So there's the same thing, sir. Minimum period of 2 years. So this licenses shall maintain the login, logout detail of all subscriber for a services provided, such as internet success, email, internet telephony, IPTV, etc. These logs shall be maintained for a minimum period of 2 years. Next, sir. Sir, one provision has been, as you all know, as I was just discussing at the initial stage, sir, we have adversarial justice system. Here, the role of a judge is a passive, but as per section 165, again it is 165 also, they said that the judge can put any question to the witness. That is a court question. Court can call any person as a court witness. But what court cannot do, that has been incorporated in this new BSA, Bharatiya Sakshya Adhiniyam, that red one. Lastly, I have said this in section 165 that says, provided that court shall, no court shall, I'm so sorry, provided that no court shall require any communication between the minister and the President of India to be produced before you. So any communication is there between Honorable Minister to Honorable President of India, then such communication cannot be called even by using section 165. Earlier there was a privileged communication, that secret information, etc., etc. So this very specific provision is there. The earlier, I remember Article 122 or 121 is there, that any discussion of the parliament or parliament commentary cannot be adjudicatable by the court. So now they have said, if some communication is there between the Council of Minister then to Honorable President, then this cannot be called to be produced by the order of the court. And this is the new law which has been brought. So I wanted to just bring it to your kind notice. Next, I believe I am done now. Next. So these are my personal day, and I will be very happy if you share your valuable suggestions. And I can improve myself. So that's what I have earned with passage of time. Any questions?
Sir, the participants are requesting to answer a few of the questions, sir.
So please.
And first question is that they would like to know that one or two examples of explanation 4 to 7 which have been incorporated into the primary evidences. Any example you'd like to give, sir?
Like, sir, if I will give an example of a very layman. So a group is there of the WhatsApp group. So he has passed some message and automatically it has been stored in more than 2 or 3 mobile phones simultaneously. Then this can be recorded, stored simultaneously. Then everyone is a primary evidence. If any system is there, then besides in the office of, let's say, DCP, ACP and other places also, the same is getting stored. So everyone is now a primary evidence. Sir. Any other questions, sir?
On you.
So suppose that if IO, our previous IO is not did not collect the 65B certificate or the certificate under the law, whether the SHO can produce it?
Obviously, sir. So that's why we have just read in a judgment that was produced subsequent to 6 years also, sir. So there is always a provision. If CBI versus RA Spy is a best judgment that was on the basis of Supreme Court judgment. That says okay, the things which is not expressly barred. So the Supreme Court has said if further investigation is not barred, then where is the question of not producing a thing which could not be filed earlier? So this judgment is there. And then one judgment is there. I remember that judgment says Hassan Bhai, Wali Bhai, Qureshi versus State of Gujarat. They said even during the trial, if some illegality or defect has been found to have been found during the investigation, then they have said this can be cured by way of further investigation. And that was done in that very case also, sir. So, and then the Supreme Court has said that the further delay will not come as a hindrance as it is justice is being imparted. Justice means truth. So, as you have said, that if IO has not been able to, the other IO or the SHO can get it filed or can file.
Thank you, sir. Another question is, sir, if CCTV footage transferred from the installation place to one server. So who would be considered as a person in charge of the server?
Sir, obviously that has to be second, who is the in charge officer over there. That's what I have said, sir. This question needs to be addressed, sir, as like a peon type person. I'm so sorry. Sometime we have seen the certificate are given by the duty officer who are of a rank of head constable. So always I have said, so it is not required because they are not the in charge persons. So the computer in charge or whosoever by any of the designation is known, he will be the in charge persons.
And sir, last question is that, sir, please, they would like to know difference between burden of proof and burden of onus.
Onus. Sir, burden of proof is always on the prosecution. Sir, burden of proof means if I wish to make the court to believe that X is Y, so it is my case that I have to, the burden on me to prove X is Y. This is burden. And onus keeps on changing, like a case of that two example I can give of the case of dowry death. If death has occurred within the period of 7 years from the date of marriage, and if we have been able to prove before the court that the lady was subjected to cruelty or was coerced for demand in connection with demand of dowry, and the death is unnatural, then it shall be presumed to be dowry death. So onus has shifted on the other person to disapprove that no, we were having a very cordial relation. So this is onus. So again, I would say as per 106 of the Evidence Act, the initial burden is the prosecution. If we have able to prove that during the period of 7 years, the girl has died an unnatural death and she was subjected to cruelty in connection with demand of dowry, then sir, the onus would be shifting on them to prove, no, we have been a cordial relation. One. Secondly, in a case of gang rape, if there is a question whether the girl was a consenting or not, in that very case, if the girl says no, then court shall presume the no, sir. So the onus keeps on changing. It shifts on the accused, but initial burden is always on the prosecution. So this is the difference.
Sir, there are some other questions also, sir. One question is like this, can section 165 BSA will be applicable to governor with state ministers?
I'm sorry?
165 BSA.
165, yeah. So
yes,
no,
sir.
it is there a minister to president of India only, Latin, sir.
Okay, it's not governor.
So
Okay,
what I
sir.
feel is that just many of must have been to Vaishno Devi. I give an example. So there is a Earth Kumari. So it used to be obviously solid rock, but after using this thing, it has become so smooth. So the honorable constitutional courts will come forward and they may give some interpretation to this thing. So it is new. So I'm very sure our constitutional courts will give something. So as per law, as I've gone through, this is minister, union minister and president.
Sir. So, sir, one important point, and it has been repeatedly asked. So, the same rephrasing, I'll rephrase the questions. Sir. There are 2-3 questions, same types. So, we are going as a police officer to somebody's house, sir, and we find that there is a CCTV footage, and we want to seize the CCTV footage.
Right,
Now, the
sir.
CCTV is stored in the DVR, so obviously the DVR becomes the primary evidence for us, ideally, to get it. Now,
Right.
when we are doing the primary evidence part, we wanted to record, seize the DVR as a primary evidence. The best evidence rule applies. But in case of a scenario that suppose that this DVR the record is not a typical manual DVR, it is connected to internet. It is IP based. So अब IP based है तो मतलब सर्वर में है सर. सर्वर में इसका मतलब है उसको डाउनलोड करना पड़ेगा. डाउनलोड करके एक ऐप है जो कि हमारे जो पर्सन के कंप्यूटर में सेव्ड है और वो अपना पर्सन कंप्यूटर खोल के दिखाता है हमें. ऐप से वो वीडियो भी दिखाता है और उसके बाद अभी हमें वीडियो की कॉपी करनी है. Now, when we are doing that entire thing, it is automatically becoming secondary evidence and we have to follow 63, sir. So
Right.
once we are coming to this point of following 63, the first question arises that who will sign the part A or the section A of it, which we believe it will be the person which is answered by the act section itself, who is in the possession or in the management or in the every day-to-day activities of seeing that this is working normally. Need not be the owner, but anybody who has the custodian of it can actually give 63, that is 65B certificate. Correct,
Right.
sir?
Right, ma'am. So what I feel is in that very situation, say I'm a person, maybe millionaire, but I don't know right also. So I'm not educated one. So I have employed some person who is taking care of the entire system. So that person, though I'm an owner, but that
Yes, sir.
person will be in charge of so. So in
Yes.
your scenario, I believe the person in whose house this is fixed, from where we have taken, he should give the second decision.
Yes, sir. Now, in that scenario, when we are taking the certificate, the question and the big question, elephant in the room is, uske niche ka section B kaun bharega, sir? And this is like a very
Sir,
big elephant in the room.
I wanted to just escape one thing, just discussion. That's why I'm saying when there is a hash value. So if
Sir.
hash value is given by the person who is giving part A, and then
Sir.
again it is given by the expert, and then expert as of date means the person who has been notified by the central government in official get of section 79A.
Sir, even if you observe 79A, sir, they are giving that certification laboratories. Even it's
Right.
not even a
It is
person
not a
as
person,
such.
right? It is not a person. It's a laboratory. So that, and otherwise also, because you have, I have not been given the very opportunity of Bnss that says 173(6).
Sir,
What say? It says
Yes, sir.
an information regarding any offense which is 7 years
Chain
or
of
more,
custody.
then the forensic expert shall go. And there
Yes,
is no
sir.
definition of forensic expert as on date.
No, sir. No, sir.
So
There's no
obviously,
definition.
there is a time limit of 5 years. So we will improve all these things. So again, I would say the Honorable Supreme Court of India or the different high courts will come out and give some answer to our questions because the baby is very small. I'm
Yes,
so
sir.
sorry. Baby will come on 1st of July, and with passage of
Sir.
time, this all confusion will be clear.
Sir, one question is there, sir. It calls about it is in the definition clause, sir, of evidence. The word inquiry has been used, but as per section 2K of BNSS, the word inquiry does not include trial.
Right. So inquiry basically is defined, earlier also it was defined, so that there are two things, ma'am. So inquiry is done, that is called, in relation to the police, is a preliminary inquiry. So this very, I would say, the Gangotri of this entire is, again, I would say the journey of this thing, that is Bhagwant Kishore Joshi, estate of UP versus Bhagwant Kishore Joshi. There was a question was put to the court, said if it is a duty mandate as per the CRPC that if cognizable offense is made out, then the police is duty bound to register the case. But
Yes.
whether the cognizable offense is made out or not, there to that very limited scope, we can conduct the preliminary inquiry. So the Supreme Court has said, the larger bench, it is 3 judges bench, ma'am, they have said the things which is not expressly or impliedly barred cannot be presumed to be barred. So they have said, that is nowhere said you cannot conduct the preliminary inquiry, right? So that has gone to the, and journey has come to an end. Temporarily, I would say the 12th of November 2013, when the constitutional bench of Lalita Kumari has said, they have said, yes, inquiry can be done in all the condition, and they have given certain illustration. This is not exhaustive. So it will depend upon the fact to fact. and whether inquiry is required. So this is called preliminary inquiry. So you can make the preliminary inquiry, but inquiry is always done, that is 202 of CRPC old, that is done by the judicial officer, not by you. So you will be doing the preliminary inquiry. That for the limited.
Yes, sir. Sir, there are some other questions, sir. One thing, for example, the question is, in cases now, we have yesterday also discussed, sir, we have also drafted something in which we are basically doing the entire search and seizure ka audio-visual recording. How is it supposed to be done? Either a mobile phone or we are using a video recorder and all the things. So when we have also been discussing about it, we are discussing it to be saved ideally in a memory card, and later the memory card is also being submitted. And in that entire thing also, there is this portion, if obviously that also becomes evidence. Now, once that is an evidence, will it be mandated that we have to give a 63 certificate? The logic says no, because it is primary evidence. If it is a primary evidence, there's no question of 63 certificate being arising at all. If I'm recording something in a memory card, and it is getting recorded in a memory card of a video recorder, I'm doing a search and seize procedure under 185 or 105, sir, new Bnss, and that mandates me to video record it. Now I have video recorded it with the help of a memory card in a video recorder. When I'm doing that entire process, I am actually documenting that entire process, taking out that memory card. It is getting documented in the Panchanama itself. Will that be requiring a certification of 63/65B?
If you go by 105 of the BNSS, I think what the Delhi police has, I don't know how many officers of Delhi police is there. If Chaya ma'am is there, she can also say so. So that says, the law says, forthwith we shall be sending the same, transmitting the same to the district magistrate, then comma, then subjudicial magistrate or judicial magistrate. So once we have already transmitted it to the judge sahab, and the original it has been transmitted, so it should not be. Again, I would say.
So same sir, original के लिए नहीं चाहिए, उसकी अगर कॉपी बनाकर हमने दी है तो उसके साथ हमें अटैच
उसके लिए चाहिए. अगर दूसरी बात आप देखें मैम कि उस वाले में ना आप अगर 193 के देखें तो उस वाले में हमें ना ये भी बताना है कि वो
chain of custody, yes sir.
Chain of custody. So we will be describing all these things, sir. But what you have said, sir, since it is, we have already videographed, and that has been, as per Delhi police, it is automatically got transferred to the judicial magistrate or something, or 106, earlier 102 was there. So forthwith they give the copy to the so and so. If it has been given, then there is no question of further certification.
Sir, last question, sir. And this question is a very clear cut. He is rephrasing the question, but I'll rephrase it, sir. If an evidence is transferred from computer to a pen drive, and it is stored in the pen drive, /CD, /memory card, kuch bhi kar lijiye, is that primary evidence or is that secondary evidence?
It is
once
secondary.
Transmission.
It's a transmission is there. This is a secondary evidence. Had it been automatically
simultaneously stored,
simultaneously, then it
becomes a primary evidence. Sir, one of the topic question is there has been raised by one of the participants. I think they are also from the prosecution side. This is regarding BNSS ka provision for prosecution. This will be the last question to you, sir. But they have basically about the views of 20 BNSS, sir. That as to whether the provisions mandate for the examination and scrutiny of police reports by Deputy Director Prosecution and also monitor cases by Director of Prosecution and Assistant Director of Prosecution before police reports are presented in the court of law.
Yes, I would say before. Again, whosoever is a prosecutor, he must be knowing. Sir, there is a judgment. This is the major changes which has come when the CRPC 1898 was replaced by CRPC 1973. Earlier, the IAS officer used to be the judge and the officer also. Then they have said now the police and the prosecution were bifurcated. So they says the role of the prosecutor commences with the in the court. They are the officer of the court, and whereas the police officer are the officer of the field, sir. So that was further clarified in a matter of R. Sarla versus TL Velu Sami is a judgment, which has started wherein Honorable Madras High Court has upheld in one of the matter where the one police officer had gone to file a charge sheet. Then the judge has directed you go stick the opinion from the prosecution and then file this charge sheet. Take a call. Then this was upheld by the High Court, and then the matter has gone to the Supreme Court. Supreme Court has said, no, the role of prosecutor commences only after so and so. While deciding so, they have said it, had it been a matter or scenario where the police officer of their own had gone to the prosecution and sought the opinion, matter would have been different. We would not have walked into it. So they said the court cannot compel or the prosecution not compel. If the police is coming to Atul or anyone, then they are welcome. They can do it. So that was the R. Sarla. Then thereafter a judgment has come. That judgment is the state of Gujarat versus Kisan Bhai. That judgment of a judgment wherein a small girl was gang raped and she was killed also. And while fleeing away, they had taken out some bracelet, etc. And in order to take it out, they have used one coconut cutting weapon. So that was not the coconut seller has produced it. Unfortunately, it was not a made witness. Then the Supreme they have argued, and he was awarded death penalty. But Supreme Court has said if the culprit is roaming freely, then it was a real part. So they have said it should have been gone to the prosecutor. Prosecutor should have get it corrected and further investigated also. So this need was filled. It should be done, sir. Then now it has been brought in section 20 of Bnss, which says the punishment of 3 years to 7 years would be scrutinized by the deputy director. And while doing so, they have also added the last provision, which is very important to read, that says SOP will be decided. So if we go literal meaning, then the only cases where the punishment is 3 years to 7 years will only be subject to the scrutiny. So the scrutiny means it has to be prior to filing the charge sheet.
Charge sheet.
Right. And the 20's last paragraph, last subsection is very clear, ma'am. This is 9. For the purpose of subsection 7 and 8, that is the role of a public prosecutor and all that, during which the person has been impacted. No, I'm not on that.
No, sir. It's audible.
I'm so sorry. 11. The power and function of the director of prosecution, deputy director of prosecution, assistant director of prosecution, and the area for which each of the deputy director of prosecution and assistant director of prosecution have been appointed shall be such a state government may by notification specify. So the state government again would specify the further order, okay, what are the rules of other things. But if you go by the legislated law of section 20, deputy director will scrutinize it prior to filing in the court. So that very, I would say, the gap was widened, that has been now breached.
Understood, sir. Thank you so much, sir. I think that will be formally ending a very exhaustive session on the BSA, sir. Thank you for accepting our request, sir. Thank you for sparing your very valuable time. And it was a very big pleasure on behalf of all of us from NPA as well as from all the participants, sir. I'd like to thank you. Thank you so much for joining us, sir.
Thank you so much. It was always a pleasure.
Thank you, sir. Thank you. Thank you, sir. So participants, we will be having a short break of 5 minutes, after which we'll finish the last session of the morning session, which will be the remaining part of the BNSS. So we will be reconvening at 12:30. Good afternoon, participants. Am I audible now? Any one of you can just confirm one simple message that I'm audible. Okay. So I'll formally start the session now. This session is a remaining part of what we had already had a discussion on BNSS yesterday. And when we were discussing on BNSS, if you remember yesterday, we have done a major portion of discussion about how you could be doing this seizure procedure. And as this question was just right now asked about how we are, suppose one of the participant had just asked the question and I was not able to ask it to sir. So I'll answer to whatever that part is as per what I understand. You had asked me this, the question that was put in the chat box is that yes, even IO can record the search and audio video record the search and search proceedings under 185 or 105 through his mobile phone. If he is recording it through his mobile phone, how is he going to produce that in front of the court? Now that is the $1 million question that is going to be asked to us at every point of time. If any evidence gets produced anywhere, wherever it is first produced or wherever it is first hosted is where it amounts to be the primary evidence. So in your case, in your scenario, very rightly you have said the scenario that this is your phone is going to become a primary evidence. If your phone is the primary evidence, do you require to produce your phone? Obviously, you will have to require to produce your phone. Now, can you produce your phone every time? And you will say, ma'am, I can give a copy of it. That was the question also, that can I give a copy of it with the charge sheet? When you're giving a copy of it with a charge sheet, you will have to submit the 63 certification also. This is the crux that you need to understand, my dear friends, is that if you are not submitting the primary evidence, when primary evidence is present, that becomes detrimental to our case because of the best evidence rule. What does the best evidence rule of jurisprudence talks about? Best evidence of jurisprudence talks about is if you have primary evidence, produce primary evidence. And that is why when we had this discussion yesterday, when we were discussing even mobile phones, we are recommending only 2 forms of recording it through mobile phones. Either your mobile phone should have a memory card in which only this detail, wherever this information is being created, goes to the memory card and sits there. You take out the memory card and then seize it. Or like sir was telling you, and I have also uploaded the sakshya app manual on the Google Drive. Now, either this sort of a technology solution has to come in which it is actually being done through an app. It is not at all being saved in the phone at all. It is directly going and sitting into the server. Once it goes and directly sits into the server, it is an accepted matter of jurisprudence that server will not be produced as primary evidence. So for server, since server cannot be produced as primary evidence, only secondary evidence can be produced. And that has been taken care of with the form of these apps also. Either when you talk about the sakshya app, either you're talking about any other app which any other state might also be trying to develop. We are actually looking into all these things as of now, and they are taking care of all these points as of now. Because this academy also was a part of this entire deliberation when the Supreme Court had appointed a committee in the Shafi Mohammed judgment itself to look into the crime scene video recording and audio recording, in which this itself, the logic itself was basically placed in front of the Honorable Court also. So this is as if now the understandable principle that we have when we are talking about recording. When the question that you had asked, another person had also asked the same question. And when I was also trying to tell you, there were 3 basic documentation parts that we were doing in that audio video recording. वो memory card पे हम 3 चीजें कर रहे थे. एक हम कर रहे थे वाइपिंग, उसको साफ कर रहे थे पहले. फिर उसके बाद हमने उसके अंदर रिकॉर्डिंग की. After that, we recorded something into it. Once we have recorded something into it, then we did the hashing part of it. And if we stop at that point of time, what is that memory card? That memory card is your primary evidence only. But we also had this responsibility of making a copy out of it, which we discussed imaging and cloning and other aspects of it. So if you're recording a copy out of it, that automatically becomes secondary evidence. So this is this entire idea of how the evidence is flowing. Our people on the ground level have become quite acquainted to this entire aspect of 65B and understanding to it, although we keep on getting confused about it at some point of times. But by and large, the understanding is of these sections are like that. Now, we had discussed some things yesterday. We are discussing the remaining part of the things today. What are the parts of the things that we are discussing today? We are discussing something about arrest, and this is something which is understandable or known to you. What about this is there? That arrest ke liye, if you are deciding or there is any kind of a scenario that is arising for you for arresting a person who is more than 60 years of age, and obviously in offenses which is less than 3 years. In that cases, you do have to require to take the permission of the Deputy Superintendent of Police. You shall have to take the permission of the Deputy Superintendent of Police for recording or for basically arresting that person. So this is simplifyingly putting like that. This is once again how technology comes in. This is the CCTNS version of it. This is the CCTNS opinion on of it, how they are trying to basically incorporate these changes so as to make our life very simpler, that we just now have to add on to this part. We just have to, basically take the permission. Basically, when a permission is required, that addendum automatically arises. Sorry for the interruption. So once again, we were discussing about the arrest part. Arrest part ka arrest, yes, permission aap lenge. Permission lene ke liye bhi there is this scenario that has been created. It looks like that when it formally comes in CCTNS. Now this is what CCTNS has recommended, or CCTNS 2 is also coming up by saying these parts. But by and large, this is the presentation of whatever this is and the new changes that have been incorporated. Why we make this presentation and how this presentation, we are trying to actually collate a lot of things that a lot of states are doing, CCTNS is doing, apps are being developed, because finally as police officers, we need to implement it on the ground. When you're implementing on the ground, we need to understand what are we implementing and where are these changes being happening. Like there was a discussion yesterday also, there was this discussion that audio-visual electronic communication has now become an accepted form of communication. So if it is all electronic form of communication I'm giving, so where am I documenting that? Is that itself sufficient for service or not? So when we talk about giving arrest intimation, now arrest intimation is supposed to be given, all of us know, but arrest intimation can now be given through electronic form also. If that is being done, what will be the steps of how we are documenting it? So for that also, CCTNS makes changes in its entire thing, in which it brings the fact an arrest form is created, in which arrest form में email अगर आप डाल रहे हैं या phone पे inform कर रहे हैं, whether you are informing on email or phone, it is going to give you that option where you can enter those details also. Other than that, two minor changes that have happened in arrest, we know that, but we are, for the sake of reiterating, if a private person arrests somebody, earlier it was that as soon as possible, he should be produced in front of the police. Now they say as soon as possible is also a very generic term. It's a very subjective term. A lot of things can be this side, a lot of things can be that side. So for that also now, we have a clarity that within 6 hours, that person has to be produced in front of the local police station. That this one change has happened. One change that has been happening and which is extremely important for us to understand is that we have to understand that if you are exercising or if you're outside your jurisdiction, and if you're outside your jurisdiction and trying to execute an arrest warrant, who all do you have to inform? Now you have taken an arrest warrant, you have gone out of your district and you're now trying to exercise it. Once you are exercising it, you're outside your district, you are automatically informing your own district that you have made an arrest. So your control room knows it. The other control room where exactly you have made an arrest also knows it. And now you also have to make a responsibility of informing the person where the person usually resides. So the person usually residing, wherever the person is sitting, wherever the person is there, if he is residing, suppose a person is from Uttar Pradesh, but he has been arrested, he is temporarily residing in Bangalore, and Hyderabad police has taken an arrest warrant and gone for his arrest in Bangalore. So now 3 control rooms need to be informed. The control room of Hyderabad will have to be informed, control room of Bangalore has to be informed, as well as the control room, the designated person which is there in the place where he usually resides also needs to be informed. Very minor change, but it is there. Handcuffing, very important provision for all of us, because like yesterday, DC Jain sir was very categorical about telling us the fact is, we have sometimes lost this entire idea. Our generation has not seen too much of handcuffings happening. So now once the power has been given back to us, 2 things need to be very crystal clear to us. Kisko kar sakte hain? Who? can be, who is the person who we can actually arrest or use handcuff? Obviously, you have a own categorization of arrest, but who can you use the handcuffs on? So for this, there is this very exhaustive list that has been given, and at every point of time when we are executing it, this checklist has to be kept in our mind that this is the list of the person whom we can do it. First itself, जब हम इस list को ही पढ़ते हैं, the first point, habitual offender. No, this is something that needs to be reiterated to every one of us, that who is a habitual offenders? All of us have our own respective state laws about habitual offenders. They are disclosing, or our police manuals are there, which are basing exact categorization ki this, and then it becomes a habitual offender. So this sort of a checklist needs to be developed by each one of us when we are executing it. CCTNS cannot help us here because handcuffing is an execution that you are going to be doing on ground level. But this execution also tomorrow can be questioned. So for that, it is extremely important for us to understand that we should know and we should understand that these are the person who we can use handcuffs on, and we can use handcuffs in two places expressly mentioned by the law, which says during the time of arrest or while producing the person before the court. So this is something that we always need to remind ourselves, develop our own SOPs as superior officers of how this is actually going to get executed on the ground. Remand. Yesterday, Satyajit sir had asked a very vital question about remand, that there is a lot of disclosure, there's a lot of discussions that happening because there is a little change in how the remand has been phrased. 167/187 में change है, तो क्या इसका मतलब ये माना जा सकता है कि पुलिस रिमांड 15 दिन से भी ज्यादा दी जा सकती है? Was the major primary question that was being discussed yesterday. And there itself, sir also told us very clearly, and we are also reiterating the fact is, whenever any court makes any judgment about anything, it always goes into the legislative insight or the legislative intent of forming the law. Now, where do we find this legislative intent? These legislative intents are the part of the bill that gets submitted in the court, in the Honorable Parliament when it is there during the entire process of passing it. When we read the Rajya Sabha report on BNSS, it categorically mentions and makes it clear that the intent of the legislature is also to keep a maximum period of 15 days only. And that will be the entire period at which the police custody can be given at any point of time. 15 दिन की ही पुलिस कस्टडी मिल सकती है हमें. अब ये 15 दिन हमारे लिए बेनिफिशियल इसीलिए हो गए क्योंकि ये कभी भी ले सकते हैं during the entire portion of 40 days / 60 days, depending upon the heinousness of the crime or depending upon whether it is 10 years punishment or less. So this is an advantage that we have got now. But the entire challenge as executive police officers we had when we are looking into this 15 days idea was, a very sharp accused typically tends to end up being hospitalized for 15 days and we end up losing the chance of taking him for police custody. Now that was the entire logic, while this exception has been incorporated very rightly so into the law now. But that challenge actually still remains. We just require a more cleverer accused to use it once again for 40 days or 60 days. But the fact is, as if now police custody is for 15 days maximum. It can be taken either in bits and pieces during that elaborate period of either / 40 days or 60 days. This is the entire crux of it. When we talk about certain changes that have been incorporated, अब हमने discussion ये हुआ है जैसे we all know that we are requesting that the court is actually mandated not just to record the confession, but also to record certain other statements under 164 itself. So when the court is recording statements, the court is mandated to record statements of victims, specifically victims of sexual assault and other cases. And when that mandate has been incorporated as per law, there was always this discussion of how it is getting executed on the ground. In 2014, we had a Tarkari Shivana versus State of Karnataka Supreme Court judgment, which finally put some clarity as to who will be this judicial magistrate? Will she be a lady judicial magistrate? Are we supposed to get a copy of this 164 statement as IOs? So this was where Shivanna versus State of Karnataka gave us a clarity कि हाँ कब हमें मिल सकता है ये information और क्या. Now that entire that clarity that was there under this judgment has now been incorporated into the law per se, which gives us this clarity on three portions when we talk about 164. First, if you are recording the statement of a female victim in all those cases of rape and others which have been enlisted there, it is ideally recorded, will be preferred to be recorded by a woman magistrate, in her absence by a male magistrate in the presence of a woman. In some cases also, like as sir was very rightly pointed out yesterday, sometimes we do encounter courts where or something where we as police officer actually want to get 164 statement of other witnesses done. Like, for example, I have an eyewitness of the crime, and before I want to go ahead with the arrest, I want to record his 164 statement so that tomorrow he doesn't turn hostile. Now, there were instances in which we were having a reluctance, and we also did not have a proper legislative mandate where it was actually mandated by the court to record our statement. So here now that mandate has come. Here it very clearly says that for offences with punishment of more than 10 years, anybody whom we are producing, the magistrate shall record the witness statement that had been brought in front of him. So this is something which is quite good for us, if you ask, for the execution of this process. We now have the medical examination portions. Now, medical examinations, nothing major has changed. Just without delay tha, within 7 days आ गया है. आपको medical examination करना है. The doctor is mandated to submit you the report within 7 days. You could have asked me the question, the entire automatic question that comes is 164 के लिए भी क्या timeline है? The answer is as of now 164 के लिए timeline नहीं है. 164 की करने के लिए भी टाइमलाइन नहीं है. 164 की हमारे पास कॉपी आएगी नहीं आएगी उसके ऊपर भी the previous Supreme Court judgment prevails that yes, a copy will be given to the IO, one copy will be submitted directly to the court. So both the things which are there in Tarkari Shivanna versus the State of Karnataka 2014 remain. But other than that, the clarity has come that now ideally a woman judge will record the 164 statement. When we come across this aspect, when we come across the aspect of medical examination of the victim, we have a clarity that it has to now be, the report has to come to us within 7 days. We have numerous victim-centric steps that have been incorporated. Iska ek list bana li hai. This list is just a summary for you. You can approach it and you can keep going through it at some point of time. I have actually summarized it here. Why? Because it is easier for us to remember when we talk about victims in toto. Like, for example, all of us know that this is something new only that has added, is 207 की कार्रवाई होती है. 207 की कार्रवाई basically means a part of the cognizance in which the magistrate has to, whosoever we are submitting the police report, has to submit whatever is being relied on to the accused. Now, in that entire part, are we giving the copy to the victim? The previous CRPC did not mandate it to be given to the victim. Actually, if you read the previous 173, an intimation only is supposed to be given to the victim, ki humne victim/informant, that we are filing a charge sheet or we are filing a police report. Here, but in the BNSS, the new change 207, which has been replaced by 230, says that you shall give a same copy of whatever you are doing to the victim also. What will the victim do here? Victim actually can rely on that and actually can contest it at subsequent point of times also. What are the subsequent point of times? We have committal proceedings. So when committal proceedings are there, can the victim file an application? Can they file an application against either this side, that side? The answer now categorically says is yes. The victim can file an application. The once that application is filed, all these things, the list, withdrawal of prosecution ho sakta hai kya victim ke permission ke bina? The answer is no. Now, this entire part, and in this also, there is something which is about using of technology, which I'll just show it to you, how we can actually, in case, and use technology in giving victim all this information. This is like a broad list that I have prepared. Subsequent to which there is this list of what CCTNS is also giving us or is hoping to give us at all particular points of time. If you remember, and I'm not going to be talking about it now when we talk about charge sheet, whether it is in charge sheet or whether it is in the list that I have provided to you, we are mandated to provide certain informations to victims. When we are mandated to provide certain informations to victim, how are we providing it? So basically what has happened in every point of CCTNS forms, this is just illustrative of one of them. In all these forms, we have created a checklist where the information about the victim is also added. The information about their phone numbers are added so that at subsequent point of time, they can also be communicated. So this is one illustrative list about it. This is another illustrated list about it of how we are basically, the CCTNS is trying to work ahead and trying to basically develop all these timelines. कितने टाइम के बाद किसको अलर्ट जाएगा, कौन सा अलर्ट जाएगा, तो how will CCTNS be utilizing that entire thing? If a medical report is pending, how will the medical report be received? If an MLC is done, how an MLC will be received? So all these are the list, exhaustive list that has already been worked out by CCTNS, and that is what CCTNS proposes to deliver for us. Inquest, nothing major has changed, but one major something that I may say is major is, if you read the previous 174, it says that you should complete this inquiry into that unnatural death. And once you're completing that inquiry into unnatural death, you should forward it to the district magistrate. It nowhere says timeline for that. Here we have incorporated the timeline. Bnss incorporates that you should within 24 hours submit it to the district magistrate or the subdivisional magistrate, whosoever is your concerned. Now, this is something that all of us specifically on ground should take note of. एक इम्पॉर्टेंट चीज है जो हर एक ऑन ग्राउंड पर्सन के लिए इम्पॉर्टेंट है जाना. पहले यूडीआर्स होती थी, हम इसको अननेचुरल डेथ बोल सकते हैं, हम इसको कुछ भी बोल सकते हैं इंक्वेस्ट का, हम रिकॉर्ड भी करते थे इन सब चीजों को, लेकिन हमारे ऊपर एक टाइम मैंडेट नहीं था. अभी हमारे ऊपर एक टाइम मैंडेट है कि यूडीआर रिपोर्ट को फाइल करने के 24 घंटे के अंदर वी हैव टू सबमिट इट टू द डिस्ट्रिक्ट मैजिस्ट्रेट और द सब डिविजनल मैजिस्ट्रेट. सो दैट इज अ प्रॉपर टाइमलाइन that has been mentioned. If you observe summoning witnesses for observing a panchanama or any kind of a thing is only there for inquest, actually speaking. सिर्फ इंक्वेस्ट में 175 सेक्शन पुराने सीआरपीसी का है जो बताता है कि लोकल रिस्पेक्टेबल सिटीजन्स को आप लेकर आइए और उनको समन दीजिए, और उनका काम है आपके समन देने के बाद that they should cooperate with you and be present for this inquest proceedings. But what we have observed here is, and what has the change that has come is that now some categories have been which are now exempted for not coming. Now, who are those categories? And it is very rightly said, for a person who is more than 60 years of age, a woman, or a person who is mentally or physically disabled, so a person with an acute illness. Now, it is not a blanket कि सबको ही दे दिया गया है कि उस इनमें से कोई भी नहीं आना चाहिए. ये लोग अपने एरिया के बाहर अगर आप उनको समन कर रहे हैं, then they have been given अपना एरिया कहाँ है इनका, the place of residence. So अगर place of residence के पास ये person है तो आप उनको बिल्कुल बुला सकते हैं. They are obliged to come still and be present during that inquest. But अगर कोई बहुत दूर रहता है, उसको उसके एरिया से दूर से बुलाने का अब आपके पास ऑप्शन नहीं रहेगा. These people are going to be exempted from being called at the time of inquest also. Now, 51 and 53, we all know, koi bhi, now any police officer can basically give for the medical examination of the accused. And this actually has been incorporated in the CCTNS portion also. So CCTNS, if you observe, has this very unique thing, which is a MedLeaper kind of an app, which is the app which is being integrated regarding the medical, MLC, medical legal case intimation. Now, they have that entire thing about the medical legal intimation in which they are automatically generating medical legal intimation on CCTNS also. The medical legal request as well as receiving and incorporating medical legal intimations online. So they have done that online integration part also when it comes to it. Now we come to the part of taking signature or a fingerprint impression. Now, sir had very clearly told you that there was a Ritesh Sinha case, which was very famous for all of us because earlier there was no mention of voice sample to be collected as per the entire section 311. तो जो voice sample था ही नहीं, तो voice sample collect कैसे कर सकते हैं? If we can't collect voice sample, then how are we going to do a comparison of voice sample? So this BNSS obviously does that entire remedy of that entire portion in which both the finger impression as well as voice samples have been included now into the erstwhile 311, now called as 349. And this very categorically gives you an option of taking these samples without arrest also. But when it takes without arrest, the logic is that you have to basically give a submission or you have to make a presentation to the magistrate. An application has to be filed from your side, and a magistrate will have now that authority of doing it. Magistrate can order for a collection of samples even when a person has not been arrested. This is an exact provision which has been named, and the magistrate will record it in writing and then will issue the entire order. बेल, हमें बेल से ज्यादा मतलब नहीं होता है, लेकिन बेल की डेफिनेशन में हम वी हैव ऑलरेडी सीन दिस बेल काइंड ऑफ थिंग हैपनिंग. हमें पता है पर्सनल बॉन्ड पे छोड़ा जाता है, पर्सनल श्योरिटी पे छोड़ा जाता है, हमें पता है कि श्योरिटी के किसी और श्योरिटी के नाम पे भी छोड़ा जाता है, कभी कभार हमें पता है कि कैश श्योरिटी पे छोड़ दिया जाता है. अब इन सभी को नाम चेंज हुआ है, इसका एक प्रॉपर नाम दिया गया है विद द न्यू BNSS. इफ इट इज अ पर्सनल बॉन्ड, इट इज कॉल्ड बॉन्ड. If it is being released with the surety, it is called bail bond. Now that exactly is the entire logic of doing this, of basically incorporating it. Mandatory bail के लिए एक बहुत provision है which has been discussed a lot by jurisprudence, which says that हमारे jails बहुत ज़्यादा भर रहे हैं. हमारे jails को कम करने के लिए अगर एक person who has been incarcerated for more than half of the entire provision of his sentencing. Like for example, if a person is accused of murder, now murder had a maximum of 14 years, so 7 साल हो गए उसको जेल में रहते हुए. So we should be able, there should be a provision of mandatory bail because the conviction has not happened, the trial has not reached the final destination, so the person should be enlarged on bail. Now this logic was there in CRPC also. This logic has been improved upon in BNSS, where they bring in that entire provision of reducing one half to 1/3. पहले जो था कि आधा में, यानी कि 7 साल की सजा के बाद उसको छोड़ना है, अब 1/3 की सजा के बाद छोड़ना है. लेकिन किसको छोड़ना है? फर्स्ट टाइम ऑफेंडर्स को ही सिर्फ छोड़ना है. इफ अ फर्स्ट टाइम ऑफेंडर्स के अलावा, जैसे अभी मैंने आपको मर्डर का एग्जांपल दिया था, क्या मर्डर को छोड़ सकते हैं? नहीं छोड़ सकते. क्यों? क्योंकि उसी के लिए नीचे दे हैव एडेड अ प्रोविजंस. व्हाट आर द प्रोविजंस दैट दे एडेड? दैट this part is not applicable for offenses punishable by life imprisonment or offenses in which a person has been involved more than once or has multiple cases pending. So multiple number of cases if pending against a person, these provisions are not there. But yes, the objective of the makers of the law was very clear that there may not be certain these repeated offenders everywhere. There may not be murderers everywhere. They might actually be incarcerated for very petty offenses. So if it is a very petty offenses, it is the burden on the part of the establishment to actually release them also. And that is why they have been made that entire provision also. Regarding anticipatory bail, there are these provisions which are there which do not find the mention in the new latest version of BNSS. Now these provisions actually are also state specific provisions. They were not exactly there for everybody in 438 of CRPC, which basically says that when you're hearing an anticipatory bail provisions, you ideally have to give the PP a reasonable opportunity of being heard. And in certain states, it was also adding the point that physical presence of the accused seeking anticipatory bail was mandated. Now, both the provisions are not there in the BNSS. So these are no longer the rule of the law as of now, which will come into existence from 1st July. अब ये दोनों चीजों की जरूरत नहीं होगी. कई states में ये है, कई state specific amendments हुए हैं CRPC में where these things are there, but now will not be required to be there. Proclaimed offender, very crisply said and understood by all of us, is anybody who is punishable with offense which is now, the BNSS ka version, who is punishable, which is maybe punishable by more than 10 years of imprisonment, से ऊपर वाले जितना भी accused है, उसको हम proclaimed offender declare कर सकते हैं. तो क्या हम विटनेसेस पे प्रोक्लेमेशन नहीं कर सकते? नहीं, ऑब्वियसली विटनेसेस पे भी प्रोक्लेमेशन कर सकते हैं. 10 साल से नीचे वाले उम्र पे उन पे प्रोक्लेमेशन नहीं कर सकते? नहीं जी, बिल्कुल उन पे भी प्रोक्लेमेशन कर सकते हैं. सिर्फ उसका नाम प्रोक्लेम्ड ऑफेंडर नहीं है. The person, the nomenclature is not of proclaimed offender. And very typically, a lot of people will ask that, okay, why is that so, and how you are documenting it? The part of documentation is what I have shown you here. CCTNS once again brings in that part in which they are bringing the documentation of proclaimed offenders also there. हम कैसे उसको हर point of time के बाद उसको document कर रहे हैं. But here comes the entire crux of it. Why we are so interested in proclaimed offender. प्रोक्लेम्ड ऑफेंडर को दिखाना, डिस्कस करना इंपॉर्टेंट हमारे लिए एक नॉमेनक्लेचर इसीलिए है बिकॉज अ प्रोक्लेम्ड ऑफेंडर कैन नाउ बी ट्राइड विदाउट हिज प्रेजेंस. That is, in absentia trial is now possible under this new provision which has been brought in, which is 356, which has been said that until and unless he presents himself, he can, obviously it has a lot of provisions. It says how it has to be executed, कौन से newspaper में देना है, कितनी बार attempt करना चाहिए before the court starts this entire process of trial. But once it starts and once it goes ahead with the trial, it becomes extremely important for the other person to come because he cannot even appeal against it without being physically present. And if he doesn't appeal within 3 years, then there is no option of appeal at all. So the conviction after the expiry of 3 years it cannot even be appealed. So this is something which is very quite stringent. This is against what we have all learned till now, that accused has to be given the right of defense. But we also understand that why he doesn't want, we can't be kept on waiting for a number of period of time. We have cases that we are not able to get the accused, and just because of that, we can't give a conviction. We have everything in front of us. So definitely for that purpose, they have looked into it and brought this entire portion. FSLs, obviously, first part, as rightly said by every one of us, all of us know forensic experts have become very important for us. And not just forensic expert. If you observe CRPC doesn't define forensic expert, but CRPC does define scientific experts. And when CRPC is defining scientific expert, it is defining scientific expert under 293 CRPC. And when that 293 CRPC, are there any changes that have happened in 293? The fact is, yes, some changes have happened because now even state governments can notify scientific experts. So since there is this huge demand for all of us to improve on forensic part of investigation, forensic evidence collection has also become extremely important for all of us as a society. And now obviously the ball is in the state governments and central governments court to basically go on nominating more people for this entire portion also. Now, regarding charge sheet, there is one important aspect that I have about charge sheet that I wanted to share with you, and which our previous speaker, sir, has also just touched on that topic also. Atul sir had also touched on that topic. इसमें एक sequence, एक phrase add हुआ है. हमारा जब आप अगर देखेंगे, this is what it looks like. It was looking like that previously also. It was 173, it became 193. This last portion, if you observe, which is the sub-party I, has now been added. What does I say? I says that the sequence of custody in cases of electronic device should be documented. अब ये पहले तो हम करते नहीं थे. हमारा सीक्वेंस ऑफ कस्टडी बहुत इजी है. हमारा सीक्वेंस ऑफ कस्टडी क्या होता है? हम सीज करके लाते हैं. वी सीज एनीथिंग फ्रॉम एनी स्पॉट. We have powers under 165/100 previous CRPC. And after we do it, we send a list of it to the magistrate. Obviously, that is also the power of the magistracy. After that, we bring it to the police station. We keep it inside a malkhana. Then malkhana / whatever the name of our safe house is. And after that, as and when it is required, we take it out and then we produce it into the court. Ideally, at the time of PR, we are submitting it to the court and it is going to the court's malkhana till the time it is being disposed. So in this entire sequence, our malkhana register is never documented or never made or submitted into the court. But if you observe NDPS Act here, I think they might have drawn that inspiration from NDPS Act. But NDPS Act, there are a lot of checks and balances in which this documentation is also a part of our investigation docket only. Where जब आपने उसको सबमिट किया, जब भी सीजिंग ऑफिसर ने उसको सबमिट किया, जब आईओ ने उसको टेक ओवर किया, दैट एंटायर थिंग इज डॉक्यूमेंटेड. अब करना कैसे? How do we ideally do it? Now, I don't have a direct answer for it, but I searched for that answer in the thing and I found some sort of a system which can actually be incorporated and followed by all of us. But this is left to the state governments to understand how they want to follow it. So every one of us can be our own thing in which we are documenting it. This is basically where they're documenting हर एक डिजिटल एविडेंस का एक अलग डॉक्यूमेंटेशन रेडी होगा. उस डॉक्यूमेंटेशन में एन इंपॉर्टेंट पोर्शन विल बी देयर व्हिच विल बी द चेन ऑफ कस्टडी. कब थी, किसके पास थी और किसके पास क्यों थी, मतलब द डेट, टाइम, wherever the person who has taken it, the person who is giving it, with the signs and signature of the locations also. Now, this has been taken by from the Western world. This is the US departments, departments of commerce example. But the point is, it's just illustrative. कहीं ना कहीं हमें ये चेन ऑफ कस्टडी अब बनानी पड़ेगी. ये चेन ऑफ कस्टडी अब आपकी चार्जशीट यानी कि पुलिस रिपोर्ट का पार्ट होगा. This is now going to become a part of our entire police report, that where we are making this entire documentation and presenting it to the court. So jab ye same part gets thing, and one good thing that I liked about it is what the last part is, which is final disposal. Why am I showing you the final disposal? Also, I'll discuss it with you because some changes about disposal of property has also been incorporated by the BNSS. I'll just come to the slide, and that is also incorporated here itself. And in case we are releasing it to the lawful owner under 451, previous 451, now 497, will also get documented here. So the same thing is also there. And as we were discussing, the victim-centric approach, हमने उसको copy देनी है. Copy कैसे देंगे? जब हम करते हैं तो क्या हम charge sheet को electronically file कर सकते हैं? The answer as of now is yes. We are trying to develop all this expertise where we are CCTN is going to get real time to ICGS, where we are going to be able to actually transmit the charge sheet in electronic form. Since we are submitting the thing in electronic form, we can actually do 207 ki karwai or 230 in modern BNSS also electronically. We can give it to the accused electronically. We can give it to the victims electronically. All this will become easy for us with the adoption of technology at its appropriate time. Further investigation, all of us understand it, and we have to understand this entire part. There are a lot of court judgments about whether we are supposed to intimate to the court when we do a further investigation, when we are talking about 173 subclause 8. Now, there is a Girdhar versus State of Madhya Pradesh judgment which says it is important for police officers to intimate the court whenever they are doing anything under 173 subclause 8. When they're doing something under 173 subclause 8, they are already intimating it to the court. How does this factor in? This factoring in has happened in which we are now not just informing or intimating, we are taking the permission of the court. Do we have to take the permission of the court at all points whenever we are doing further investigation? Actually, if you read it carefully, the answer is no, because here it remains that further investigation during trial. Now, when does trial theoretically starts? The trial theoretically starts at the formation or the framing of charges. There is an entire portion that happens prior to framing of charges, where the steps of cognizance, committals, 207, 230 सबकी कार्रवाई की जाती है. So उस part of time में अगर हम बीच में हैं, framing of charges नहीं हुई है, are we supposed to take permission of the court? If you read it as per the section, it may not mean so, but tomorrow it is always better to err on the right side, because already we have a Supreme Court judgment which says that you have to intimate to the court whenever you are doing further investigation. So it is always better that we intimate the court and take the court's permission when we decide to file any charge sheet, if we are not filing a complete charge sheet or where we wish to file a supplementary charge sheet at a subsequent point of time. That is what should ideally be done at this stage. Preventive action. Things have changed in preventive action. Things have become more simplified. I'll directly jump to the only point that we all need to be very, 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 very vigilant about in preventive section is 172 section, 172, which is a new part. And this itself says that if during the preventive action, if a police officer is making an order and that order is basically being resisted, refused, ignored, or any such sort of a thing, that person can be detained or removed by the police. This is a very important power that we have got. but we need to use it very, very carefully. When we are using it carefully, are there means of documenting it will automatically be the next question. CCTNS actually provides you the means of documenting it. CCTNS has created the entire preventive action register in which like Kalandar register, North India में उसको कलंदर बोला जाता है. तो उन सब का एक रजिस्टर प्रोवाइड किया गया है जहां ये सारा का सारा सेक्शंस भी डाला गया है कि आपने किस सेक्शन में उसके अगेंस्ट क्या एक्शन लिया गया. इन सब चीजों में जब आप 172 कर रहे हैं या पहले हम 151 करते थे, there was no FIR, there is never FIR, but there is always going to be a mandate on our part that if you are keeping the person within 24, if you are not releasing him, you have to produce him in front of the magistrate, which is categorically mentioned in the new provisions also. So yes, we have a lot of powers. We should document the powers very well, and all senior officers listening to it should make their elaborate effort to make it with due cross checks and balances. So there have been some changes that have been brought in regarding the cognizance stage and regarding the stages which are there. छोटी छोटी चीजें हैं, बहुत अलग नहीं है. Cognizance of special law, ये हमें पहले भी पता था कि cognizance of special law directly at the level of cognizance होता है कि पुलिस स्टेशन में उसका FIR नहीं होता है. For example, Mines and Zoology Act, Electricity Act. All these acts are special laws in which the law itself tells you who is supposed to initiate action. That person has to then submit what is called a complaint to the magistrate. The same thing has been reiterated here. It is basically been reiterated and added here in those explicit words that yes, the magistrate can take cognizance on the basis of complaint filed by the person which has been authorized in the special law. तो इलेक्ट्रिसिटी एक्ट हो, माइंस एंड जियोलॉजी एक्ट हो, ये सारे बाकी जितने हमारे स्पेशल लॉज हैं, जिसमें जहां भी डेजिग्नेटेड है कि किसको कंप्लेंट देनी है, वो कंप्लेंट जब दी जाती है तब भी वो उस समय जब फाइल की जाती है तो मैजिस्ट्रेट डज हैज अ पावर ऑफ टेकिंग कॉग्निसेंस ऑन इट. कंप्लेंट टू मैजिस्ट्रेट में हमारे लिए दो इंपॉर्टेंट चीजें हैं जो चेंज हुई है. ये पहले था प्रियंका श्रीवास्तव केस में, हर जगह पहले these were already existing, but they have been reiterated now that accused should be given an opportunity to be heard before the time the cognizance is taken. So this is now mandated. It is the onus is on them to take that take accused on board also, as well as if you observe this is something which is important for all of us because we are public servants. हमारे अगेंस्ट जब केस लिया जाता है तो उसमें there are two explicit provisions that have been added when we are taking the point of cognizance comes. The magistrate will not be able to take cognizance against public servant until and unless they hear the public servant, and also it is not or, it is and also a report containing facts of the incident is submitted. एक हमारे अगेंस्ट एक रिपोर्ट सबमिटेड होनी चाहिए हमारे सुपीरियर से, एंड हमें हियरिंग की अपॉर्चुनिटी मिलनी चाहिए. इन दोनों मिलने के बाद भी if the magistrate feels that there is sufficient evidence on record to take cognizance, he will take cognizance. But these two things have been categorically brought in, which are extremely important for all of us to know. This is what I was discussing about the new changes that have been brought in under a sister section. 451 पहले भी था, 451 से लेकर 457 पहले भी था, टेम्पररी रिलीज भी होता था, सब कुछ होता था. And this is also where something where we have faced a lot of backlash, or what we can say a bad publicity, where a lot of our things are lying up in our police stations. खूब सारा सामान हमारे पुलिस स्टेशन में है, हमें नहीं पता कैसे उसको रिलीज करना है, या फिर हम करने की कोशिश करते हैं, but there are lots of challenges to it. The major challenge what was that we always faced was this should be reproduced at the time of trial. So there has to be reproducibility at the time of trial. But if you see the same collar here before we go into 497 and go to our whatever knowledge we have of NDPS, नारकोटिक्स NDPS एक्ट के बारे में हमें जितनी जानकारी है उसके हिसाब से अगर हम उसको देखें और इसको देखें तो हम ये समझने की कोशिश करते हैं कि एनडीपीएस में एक प्रोविजन है ऑफ सैम्पलिंग. हम गांजा पूरा का पूरा गांजा चरस हमें संभाल के रखने की जरूरत नहीं है. वो सारा गांजा चरस जो भी है हम बाद में उसको सैम्पलिंग कर सकते हैं मैजिस्ट्रेट के सामने, और जब हम मैजिस्ट्रेट के सामने सैम्पलिंग करते हैं उसके बाद हम उसको रिलीज भी कर सकते हैं. जब हम मैजिस्ट्रेट के सामने सैम्पलिंग कर दी तो हमने जो गांजा था उसको क्या करेंगे, हम रिलीज इन द सेंस उसको डिस्ट्रॉय कर सकते हैं. सो कैन द सेम लॉजिक बी अप्लाइड नाउ ऑल्सो. We just had a discussion about BSA. हमने डिस्कस किया कि सीसीटीवी है, सीसीटीवी हमें सीज करना पड़ेगा क्योंकि वो प्राइमरी एविडेंस है. प्राइमरी एविडेंस सीज तो करना चाहिए, लेकिन वो एक पर्सन की प्रॉपर्टी है, हम ऑब्वियसली उसका एक रेजिस्टेंस होगा सीज करने में. We have the very, very sensational cases like Pehlu Khan case, every case. The entire world has seen the murder happening, but we still get acquittal in all these things because we don't know who has actually shot it. So why? Because in general, public also feels कि यार एक बार पुलिस को दे दिया, police will not give it back to me. So this is something that all of us need to be extremely vigilant and understand is now. 497 now tells you that the court, as soon as, like I'll just read the section first. It says that the court or a magistrate shall, within a period of 14 days of production of property, which has been preferred under this. Now, what is this property? It is during any investigation, inquiry, or trial. When the magistrate, it's produced in front of the magistrate. Within 14 days, the magistrate is now supposed to make a statement of the property. किस फॉर्म में वो स्टेट गवर्नमेंट बताएगा, स्टेट गवर्नमेंट डिसाइड करके बताएगा which form it is. When this entire thing is being done, this also should be photographed. It also should be video recorded. And then what should be done of this? Whatever this video record, photograph, and this list, whatever the list that was being prepared, the statement that was being prepared, will now be used as evidence. This is going to be now used as evidence in the court. And after this, within 30 days, the court shall order for the disposal, destruction, confiscation, or the delivery of the property back. So this exactly brings in a lot of timelines, which helps us actually as police officers, because this is going to be a solution to our major problem of a lot of property that has been kept with us, or that a property that has been with us. Community service has already been discussed. I'll not go into the things. Summons. मेल मेंबर्स हटा दिया गया है, समन्स किसी को भी दिया जा सकता है, इलेक्ट्रॉनिकली भी दिया जा सकता है. कल एक क्वेश्चन था चैट बॉक्स में कि इलेक्ट्रॉनिक अगर हम कम्युनिकेशन से सर्व कर रहे हैं समन्स को, विल इट बी कंसिडर्ड एज अ वाइटल फॉर्म ऑफ एग्जीक्यूशन? Now, my dear friends, the answer of vital form of execution of any of these process is actually left to the subjective understanding of the court. If the court believes it has been done with due precautions and the way it should be done, then it may be accepted. It may tomorrow not be accepted also, because the court may not accept it, that you have done the subsequent thing. Why will the court not accept it? Because what will happen? You will send it on WhatsApp and then you show 2 blue ticks. You and me both know that the blue ticks can be shown without actually being delivered. Or we can create an email and show the delivery of the email. You and me both know that we can actually change the name of the email also, and we can do a lot of things with email also. So there is always going to be this checks and balances. There's always going to be a demand, but as if now electronic form of execution has been accepted. So once it has been accepted, we should take it as an acceptance only, and then wait for the further judicial pronouncement to come about these things. But the law says it will be accepted and it shall be accepted. This is an important provision. It has been discussed a lot, in which is about the idea that if a public servant or a scientific officer or a medical officer is not able to come, then can his the next in command or whosoever is the next administrative person, can he be called as for giving evidence? So इसमें 3 चीजें हैं which are very very important. First of all, किसी को भी बुलाने की जरूरत नहीं है until and unless it is being disputed. So ideally, all these records of experts should be admitted directly. If there is a dispute, now who does the dispute? Defense does the disputes at the time of admission. So when the defense is not disputing it, there is no question of calling these people at all. But if the question does arise, yes, now the provision has been there that public servant या फिर वो scientific officer या वो medical officer का subordinate officer, whosoever is right now holding the entire the authority of it, can come at that point of time. He or she can come or he or she can basically be submitting themselves for the examination of the court, and that can also happen audiovisually. A lot of discussion happens and a lot of idea happens for all IUs regarding that specifically is, are we under the definition of public servant? And the categorical answer is no. Original BNSS, the original iteration of BNSS that was brought in August did had the phrase of IO also here separately. And this was brought into a lot of discussion, and IO was separately removed. IO chahe kitna hi change ho jaye, original IO will have to come, and he is the most important sources of connecting the records here. So IOs or us are not covered by it, but yes, any evidences that we are relying on and the generator of those evidences, specifically like the scientific officer, medical officers, these people, we need not keep on trying to search for them where they have been transferred, kahan transfer ho gaye, kab gaye, unki zarurat nahi rahegi. We can use this provision, and all of us, specifically our all IO assistants, should be very well trained in it, specifically the court PCs. All people who are managing the court should be aware of it. It is no longer mandatory for us to be doing it. 530 आ गया है, बहुत सारे changes अब expected हैं. Lot of new things are going to come out of this 530. We just have to wait and watch, but a lot of things, a lot of fastening of the entire process is expected to happen. Lot of timelines are there. Some of the timelines are no important. It's not very important for us to remember it per se, but these timelines are more or less about the judicial part of it, or the part of the judiciary. Like there is a 90-day timeline for committal now. We have the timeline for 60 days for framing of charges. Then we have the timelines for 30 days for delivery of the judgment. Then we have the timelines when we come to the entire part in which the permission is not given for prosecution of public servants. 120 days it can be deemed to be given. This is quite contentious, but yes, it is there. Plea bargaining. We have now this part that if within 30 days after framing charges, the accused is not applying for the plea bargaining, he will not be allowed to be encouraged in this entire plea bargaining, submit his application for plea bargaining at all. This thing has been incorporated in which summary trials has been allowed for 3 years, for punishment till 3 years. Now, please understand, summons or warrants case की definition वही है. Summons case क्या है? Less than 2 years punishment. Warrant case क्या है? More than 2 years punishment. क्यों है summons और warrant case की definition अलग-अलग? क्योंकि उसके अलग-अलग chapters हैं, किस तरह से उसका trial किया जाता है. और वहीं एक और third chapter है, which is about summary trial. Summary trial has been now, it was previously till 2 years only. Now, 3 साल से कम के भी any offenses are there, they can also be summarily tried now. So that is a good addition only, so that we are expected to deliver it more faster. Mercy petitions also we have, like it is a common matter of legislative intent that we sometimes a lot of delay is happening in understanding or following it up, or submission, or some opinion to be given about the mercy petition. So a lot of timelines have been brought in for the mercy petition also. Similarly, we have the timeline for detention that I had already discussed with you about the punishment portion of the detention. Those is other adjournment nahi allowed hai. बहुत सारे timelines are there. Now, when the timelines comes in, there is always going to be this challenge on us of how it is going to get implemented. वो timeline को implement कैसे करना चाहिए? कुछ timeline जो policing से related है, उसको implement करने के लिए CCTNS में there have been things. But as you have already observed, none of these which I have just enumerated are about policing aspect. They are about the magisterial aspect. So when it comes to the magisterial aspect of this entire thing, it is always going to be a challenge to ask for us to understand that how it is going to be perceived. कितना आप कर सकते हैं, कितना नहीं होगा. So that is obviously going to be seen now in the near future of how it is going to get executed. One change has happened regarding offense of similar kinds to be clubbed together. We do understand that it was there previously also that when there are 3 similar offenses, similar means similar. Theft है तो 3 theft है, जिसका अलग-अलग FIR दर्ज की गई है, अलग-अलग charge sheet हुआ है. वो 3 theft, if they're happening within 1 year, not calendar year, 1 year. If it is happening between 1 year, they can be clubbed and they can be tried together. So now this entire thing has been improved on to 5. अगर 5 similar offenses हैं within 1 year, they can be clubbed together and they can be basically tried together. Once again, the judicial aspect of it, so as to improve on it and increase the entire thing. Legal aid. should legal aid be provided by the court? Should legal aid be provided at all points of the time? Should legal aid be provided only at the time when it is court of sessions? Now, this ये पहले से ही established principle है that legal aid will be provided at all times. Legal aid should ideally be provided at the time of remand also. We have Menaka Gandhi case, we have the 2611 case. All the cases were landmark in basically telling that even at the time of remand, legal aid has to be provided. Then at the time of trial also, the legal aid has to be provided. So this entire portion has now been incorporated in the Bnss itself, where it makes it an obligation on us to provide the legal aid. Us ka matlab hai the entire government, the entire section of the government. That is why it becomes important for us to know who is our remand advocate. कौन DLSA से जो अपॉइंट किया गया है कौन है वो रिमांड एडवोकेट which who has to be present in cases when we are producing him for remand. Plea bargaining, the entire actual bargaining, the entire section is same. It doesn't changes much here and there. There are certain timelines that have been entirely given. The timelines have been mentioned. A lot of timelines are there regarding the plea bargaining portion also. Deletions, we all understand that there are some things which should have been deleted and now have been deleted, in which now we have a clarity of how the magistracy works. The metropolitan is not there. We have assistant session judges also not there. Pleaders or advocate, dono bar use ho rahe the, so now there's only advocates. So a lot of things have been clarified. A lot of things have now been deleted formally from the entire BNSS. Trial proceedings, I have already summarized it for you. This is just for your reference. This PPT can be used by you for training your subordinates also. This is just a reference material for you so that you can basically be utilizing this for the retraining. But if you ask me, most important are the first part of the changes that have happened. And in that first part of the changes, the second part of the changes that we are discussing are more about the judicial part. Judicial part also, there are certain things that is important for us to understand, but certain things are 101% implementable by the court only. So we'll just have to see how it is getting implemented in the court at a subsequent point of time. Digital aids, yes, a very big important thing in which we basically have to understand, चाहे वो समन हो, चाहे वो FIR की डिलीवरी हो, कुछ भी हो, we have to understand that now electronic communication has been adopted. We have to understand we may do audio-visual recording sometimes, but we have to do audio-visual recording sometimes. How to be done that audio-visual recording, we have elaborately discussed it yesterday also itself, in which we have actually told you about those steps that should be ideally followed when we are doing the audio-visual recording. That itself is the crux of everything that we are discussing. Either it is transmission of electronic communication or it is creation of electronic record, which is going to be your audiovisual recordings. So both the times, whether it is transmission or whether it is this, most important crux of it is documentation. We should know how the process works. We should be able to educate ourselves to the bare minimum. Everybody should understand these important aspects of hashing. You all must have seen 63 wala form. And in that 63 form, the biggest question that everybody asks us is, why and how will everybody be able to understand? How will the people be able to understand that what exactly is the hashing? यानी कि hashing एक आम आदमी owner of the computer को कैसे पता होगा? उनको नहीं पता होगा, हमें पता होना चाहिए सबसे पहले. इसलिए वो तीनों चीजें, वाइपिंग कैसे करना है, हैशिंग कैसे करना है और उसके बाद उसकी कॉपी ऑब्लिक इमेजिंग कैसे करना है. We have to learn. All of us have to learn, whether we are very senior or whether we are very junior. All of us need to be extremely vigilant about our entire thing to understand it also, so that we are able to be able to give a more what you call effective implementations of the changes. The lawmakers have very good intent in mind. Now it is left to us to implement it. We may say it is very difficult, but even if it is difficult, we can do it. We can definitely do it about this entire implementation of it. It's all in our hands now. How well we understand CCTNS, how well we understand technology is now going to be our entire question. So that brings an end to my presentation, sir and ma'am. We will be and we are uploading a lot of these things in the drive. I hope that you are able to access the drive. Okay, I'll just, some questions are there and I'll just finish on with the questions. Then we'll break for lunch. Trial would be applicable. Whether abstention trial will be applicable only in cases where accused is facing trial, absconds to evade trial as declared proclaimed offender, or abstention trial is applicable also in respect of person absconding during investigation. My view on this is, sir, it is 0356 is only for people who are declared as proclaimed offenders, sir. And 336, I believe, is something where they have also done the changes upstairs, in which they have done the changes when a person during investigation also absconds. So that are the two answers to that point, sir. We will try to submit. See, that's why I was requesting all of you to please enroll in the form. Until unless we have your formal email IDs and until unless you have enrolled in our this training, we will not be able to submit you the PPTs. We will definitely try to compile it. DCJ sir's PPT is also there uploaded in the Google Drive. Mrityunjay sir, I'm not able to understand your question actually. 223 to A and B offense alleged to have been committed in course of discharge of the official duty, implications on PC Acts. But I think it's pretty clear. Those, even if during that they have to be prosecuted. So which knowledge used, either victim or local knowledge or as per law. Very important question, sir. That is always going to be an option or challenge for all of us. कि उसको access कैसे, उसको समझ में आया कि नहीं आया, और accused को समझ में आया कि नहीं आया, victim को समझ में आया कि नहीं आया. सब entire part is always going to be under contention. वो हमेशा contention में रहेगा. इसलिए हमें कोशिश करनी चाहिए that we be able to transmit everything in the understandable knowledge, understandable language. So the question is, the answer is, if you can do it in all, and try to communicate in the language in which it is understandable to the person. I think that will be the final question for this. How to enroll? Sir, please don't submit your emails here. There is a form that I'm submitting. I'm once again submitting that form. I'm once again right now submitting the drive. I'm submitting all once again. Please enroll yourself. एक Google form है for this training. Enroll it in it. उसमें अपने आप आपका email ID हमारे पास receive हो जाता है. If we are receiving the email ID, we are going to be able to send it across to you. Other than that, we have once again shared the drive link to all of you. So that will be all from my side as of now. We'll be breaking for lunch. But before we break for lunch, I have a small request to all of you. I am submitting the feedback form for today. We still have one session in the afternoon, which is a session at 3:30 regarding terrorism, where our expert from NIA is joining us about the addition of these points from this. But I'm also actually right now sharing the feedback form with you. So that one request will be that all of you please also fill the feedback form also. These are the all 4 links to everything. Joining formality links is there. Then the details of participants link is also there. And we have you have also added the drive link as well as the feedback form link. So feedback form link, I'm requesting all of you to please open it and give it after you're finishing the session, but don't forget to do it. It is extremely important for us to understand feedback so that we can also improve on it. With this, we'll officially break for lunch. It is 1:30. We'll be assembling once again at 3:25. The guest will be arriving here and we'll start the sessions at 3:30 sharp. Thank you.